Imagine, if you will, waking up in the middle of the night, your dog's barking, something feels off. You walk down the hall to check on your daughter, your now 14-year-old daughter, and her bed is empty. And there's a hoodie with a stuffed animal. Under the covers, a decoy left behind. Your stomach drops. You tell your wife to call 911 to report her missing, but you just can't sit there. You just can't wait. So you get in your truck and you go to look for your child. You're driving through the dark, searching, praying, and then you see it. A white F-150. You recognize that truck. It belongs to the same man who was arrested just 3 months prior for assaulting your daughter. The same man who faces 43 felony charges stemming from R, grooming, SSAM, internet stalking. The same man that a judge released on a $5,000 bond. And your daughter is in that truck. You flash your lights, you honk your horn. He won't stop. So you make him stop. Get out with your firearm. You're screaming for your daughter to get out of the truck. She's not getting out of the truck. You tell him to let your daughter out of the truck. She's still not coming out of the truck. Instead, he gets out of the truck. And he steps towards you. And it looks like he has something in his hand. You don't know what it is. And he's lunging at you. Fuck you. You do what any father would do. You protect your child. Now imagine this. Your daughter is safe. The predator is dead. And the state of Arkansas is now charging you with murder. Imagine that. Well, Aaron Spencer doesn't have to imagine it. That's his reality. I am Bob Mata. This is Defense Diaries. This is our continuing coverage of the Aaron Spencer case. And as always, I am joined by my beautiful and brilliant co-host, Allie. What's up, girl?
Hey, babe. Hey, y'all.
Hey, love. How you doing?
It was it was a little bit difficult getting situated, but I'm all right.
You poor little thing. All right, y'all. So there was happy Thanksgiving Eve to those of you on this side of the pond that celebrate that particular holiday. For those of you on the other side, happy Thursday. So, all right, we are going to go through a huge amount of filings, trials bearing down. There was a motion deadline date, and the flood of motions in limine and other motions came in yesterday. Tracy has been feeding them to me nonstop. Every time I think I'm out, she pulls me back in. So there's a lot of them. And we're going to go through them all. Many of them are very brief, 1-2 pagers. I think the longest is like 13, 14 pages, but it's worth going through all of them. We have told you time and time again over here on our channel that the war in any trial is fought pre-trial. This is one, everything's figured out. What's coming in, what's staying out of trial. So these are critical motions that are being filed. They'll be litigated down the road. The judge is going to have to make decisions on all of them. So I'm going to start pulling them up. Babe, you have the email. I don't know if you want to be able to look at them. I kind of went chronologically the best that I could. So we're filings on the 24th, the 25th, and the 26th.
No, I'm just going to trust you. I'm contemplating going up to get my sling because this situation I have here is not working right. But
sling blade. Give me them no French fried there. They good. I like the way you talk. All right, let me see. All right, let me pull up. Find it.
Hey, it's Weird Debbie's birthday.
What?
Happy birthday to ya.
Yeah.
You finish.
Happy birthday. We were right on time. Happy birthday to you. Happy birthday. Man, you butchered it.
I was doing the last one.
Hey? All right, hold on. I got to find this. I got to see where this doc is. Wow, I got a million Chrome tabs open. Okay, let's see. See, I moved it over here, and now I can't find it. Ay. All right, let me see. It should be like right there. Where you at? Why are you hiding from me? Nope. Okay, Chrome tab. Bear with me, kids. Bear with me. I'll find it. Bear with me. See, this is why I use the second screen all the time.
Meanwhile, hello to Maggie Cat too. She's a new member. What'd she get, babe?
Oh, family hug. So I have ads on because you guys have not been impressing me with supers lately. So, the super grift, I just can't. You guys aren't holding up your end of the bargain. So sadly, I have to have ads on. I watched Aiden's thing and he got $500 in 3 like Venmos. I'm like, holy shit, this dude raking it in. Speaking of which,
good for him. I'm very happy for him.
He needs it for his defense, which leads me to a big ask for you guys. We're going to be dropping the GoFundMe for Aaron Spencer's defense fund. They are going to have to pay a fortune for lawyers in this case, and they could use all the help they can get. I'm also planning on doing a full-out fundraiser where I have other creators come on and have them discuss the case, and we'll see if we can raise some money for the Spencers beyond what you guys are willing to do. I know times are tough. I know that the reality of the situation out there economically is brutal for people, but whatever you can spare would be greatly appreciated. I promise you that. All right, okay. Yeah, it's so weird. Pops up now. Okay. All right, so we got this guy. This is the first one that was filed. Well, there was a slew that were filed, but this one is a brief in support of motion for additional time to file pretrial motions. As I said, the judge had given a drop dead date as this trial is fast approaching in the end of January. So this thing's coming. And, when you add in the holidays, which a lot of lawyers and judges just don't work during the holidays, or courts are very slow during the holidays. So that's kind of that last 2 weeks of December is going to be pretty slow moving in terms of getting stuff done in the courts. So there's going to be some heavy duty pressure after the holidays are done to get things rolling. So this first one starts with the defendant, Aaron Spencer, buying through his attorneys, Lassiter and Casanelli states, let me see, for his brief in support of the motion for additional time to file pretrial motions. The state has provided discoverable information in a piecemeal fashion over the last year. In the last 2 weeks, the information produced includes the majority of the necessary information for trial. For instance, last week, the state produced several different hard drives full of files, some old, some new, that included several items of evidence that the state now seeks to introduce that were not referenced or discussed previously, including from two experts who analyzed evidence that had never been previously disclosed. Neither the data nor the expert analyses had been disclosed until Friday, November 21st of 2025. The state also produced files to replace previously produced files that were inoperable or inaccessible. As of today, the defense is still awaiting additional discovery material. The defense therefore cannot prepare and file all motions relevant to information either just received or not yet received. Of course, there may be no additional motions necessary, but that cannot be known until the evidence is fully reviewed and analyzed. Makes sense, right? In order to expedite this process, the defense is utilizing every resource to conduct this review and analysis on the information received late last week, and anticipates this to continue after more information is received. The defense is filing several motions pertaining to the recently received information, despite having had short time to do so, and it is not withholding any necessary motions at this time. Footnote 1, for instance, on today's date, the defense is filing a motion related to the data and associated expert analysis provided on Friday, November 21st of 2025. The other data and associated expert report produced on Friday is still being reviewed, and the defense is awaiting a response from its own expert as to whether there is any need for a pretrial motion addressing that potential testimony. All right. So, however, back to the body, review is ongoing and there may be need to file additional motions. In general, motions in limine can be filed at any time, and it is likely any future motions would be motions in limine directed at evidentiary rulings. However, there is also the possibility that a more substantive motion may be necessary. The defense will certainly file any necessary motions as soon as reasonably possible. The defense may also raise motions in limine orally at a pretrial hearing if they do not require any preparation or evidentiary hearing. So the defense thus requests the court permit motions to be filed after the pretrial motion deadline if related to information from the state that has only recently been disclosed or will be disclosed in the future. So there you go. There's the first motion by the defense. The second motion that was sent over to me, this again was filed on the 24th of 2025, so a couple of days ago. And this is the state's motion in limine to exclude background facts not known to Spencer at the time of the offense, pursuant to Arkansas Rules of Evidence 401 and 403. So comes now the state of Arkansas by and through the Lonoke County prosecuting attorney, and for its motion in limine states the following: the state moves that the defense be prohibited from eliciting any testimony or presenting any evidence regarding prior misconduct by Fossler that Spencer did not personally know at the time of the shooting. So wherefore the state requests that the court grant its motion and enter an order barring to alleged prior bad acts or character traits of the victim that were not actually known to Spencer at the time of the shooting. So that one we told you was coming. In terms of when you're thinking about what happened that night, in terms of what's relevant to the determination as to whether or not Aaron was reasonable in his beliefs that night, they're not going to be able to introduce all of Fossler's nasty, nasty history because Aaron didn't know it that night. So it's going to be limited to what Aaron knew at the time of the shooting, if that makes sense. So this thing is going to get granted. I don't think it matters. I mean, yes, of course, it would be wonderful to be able to air all of Fossler's dirty laundry. It would certainly make it a lot less anxiety-ridden situation for Aaron in court if you were able to get that out. If you can dirty up the victim here as much as you can. But the reality is that this thing is most likely going to be granted. I'd be shocked if it wasn't. All right, so there's that motion. Okay, then we have another one filed on the 24th, the motion to exclude evidence concerning cell phone tower data. So this is brought by the defendant, Aaron Spencer, by and through his attorneys. Aaron.
Sorry, I was muted. I did want to chime in there.
Oh, good.
I just struggle bus to get this freaking headphones back on. I was like,
was it adorable like it was the last time?
oh, God, it was not right. I thought you could see me, but you were reading, so like see me backstage. It's possible that the state could open the door if they try to put on any evidence that,
he's a good guy.
Yeah, suggesting that, but they're not going to fuck something like that. They're not going to open the door like that, likely. But as a general proposition, yeah, what you said, they're definitely granting it. It's black letter law. It's not relevant unless, of course, they make it relevant somehow.
Yeah, I mean, that would be a massive blunder by the state if they did that in terms of opening the door. But
yeah, that would be, to like his any history of violence. None of this other stuff. None of his criminal background that he didn't know would I don't think ever become relevant. I don't see how they'd open the door for that. And yeah, unless they tried to somehow suggest that, but that wouldn't happen. But I meant as far as his intent at the time, like that he wasn't aggressive or he wasn't known to be aggressive or violent, something like that. Could open the door up to those kind of behaviors, not necessarily the other child-related incidents.
Yeah. All right. So for his motion to exclude evidence concerning cell phone tower data, one, Spencer's charged with the red rum in the second degree. Two, the discovery file disclosed by the state contains allegations that the state can use cell phone location data to decipher the location of a phone and therefore its owner at a given time. Three, while the evidence at issue essentially shows what is already known about Spencer's case, it still must be excluded under rules 401, 403, 702, and 803 because this information cannot provide precise location information. It has no relevance and instead will confuse and mislead the jury as to its reliability and the reliability of other evidence, and it will prejudice the defendant while providing no probative value. The most that the data can reliably show is the general area of the events, which is not in dispute. While the state suggests that this data can pinpoint a phone's location as inside or outside of an area, that is entirely impossible. Spencer also objects to the introduction of any testimony or evidence claiming to be able to discern the location of the phone at various times because it does not meet the threshold for scientific testimony. Such evidence does not satisfy the requirements set out in Daubert and is otherwise speculative, unfairly prejudicial, and lacking in proper foundation. Do you want to say something?
I want to hear what the rest they say, and then I will.
Okay. There is no accepted methodology that would support the opinions suggested by the state. 5, even at a cursory review that the council has been able to do between receiving the PowerPoint from the state on Thursday and Monday, when the motion is due, the PowerPoint appears to contain erroneous information about the process and its functioning. The report and conclusions also appear to include and rely on data that has not been provided to the defense. The court should not permit any additional supplements of data and should instead exclude this expert testimony at trial for this reason and all the reasons herein and in the accompanying brief in support. So wherefore, Spencer requests that the state be prohibited from eliciting evidence purporting to give the particular location of a phone at a particular time, including testimony and the PowerPoint presentation and any part thereof, and for any other relief the court finds appropriate.
Okay, so what we need before I comment is the brief. Let's see there's got to be a reason why they're making these claims over and above just the straight technology of it, because obviously we've seen many a times where.
Okay, let me find the brief. We're done. Okay, states. You're going to have to bear with me. There are a shit ton of filings. Okay, let's see here.
So I'll just speak generally, and you know what? Maybe I can find. Maybe it's easier in the.
Okay, I got it.
Okay.
Okay. This is it. Okay.
By the way, Tracy just sent us the state's motion to extend the deadline for pretrial motions.
Yeah, I got it. I saw it.
I don't think we need to read it necessarily, but they're
Yeah.
asking for additional time. When's
All
the trial in this set?
I believe it starts January 26th.
The judge might give him some more time.
Aaron wants to go to trial.
No, I mean more time keeping the trial date the same, but more time.
Oh, yeah. Yeah, no more continuances. Let's get this thing to trial. All right. So, brief in support of motion to exclude evidence concerning cell phone tower data. Okay. So, the defendant, by and through his attorneys, states for his brief in support of a motion to exclude evidence concerning cell phone tower data. One, the discovery file disclosed by the state. I've got a footy here. So again, the state disclosed this information midday on Thursday, November 20th, 2025. The second to last business day before the motion's deadline on Monday, November 24th. The expert CV was provided today, November 24th, 2025. Defense counsel are still working on reviewing and analyzing the report and the related data. All right. So the discovery file disclosed by the state contains allegations the state can use cell phone location data to decipher the location of a phone and therefore its owner at a given time. Specifically, the state has disclosed a 12-page PowerPoint presentation with 3 slides showing the purported location of Spencer's phone at various times near the time of the charged act. While the evidence at issue essentially shows what is already known about Spencer's case, it still must be excluded under rules 401, 403, 702, and 803. Any marginal probative value the evidence has, which Spencer does not concede, is substantially outweighed by the very real dangers of confusing the issues, confusing and misleading the jury, and unfair prejudice. Spencer objects to the introduction of any testimony or evidence claiming to be able to discern the location of the phone at various times because it does not meet the threshold for scientific testimony, including the above mentioned PowerPoint presentation or any testimony based upon it. Such evidence does not satisfy the requirements set out in Daubert, which was adopted by Arkansas and Farm Bureau Mutual Insurance versus Foote, and is otherwise speculative, unfairly prejudicial, and lacking in proper foundation.
So the brief itself is about to get into the Daubert requirements. Daubert is the watershed case that most states follow for the introduction of scientific evidence and how they test it to make sure it's reliable and it meets, it meets that the judge first determines, all right, this is even something that a jury should hear, and they'll explain it more in the brief here.
Right. All right. So Daubert requires that any scientific testimony or evidence be reliable. The focus of Daubert is that any scientific testimony or evidence must be examined on the principles and methodology, not the conclusions. The mere fact that there is a certification does not mean that a particular protocol satisfies Daubert. For example, law enforcement officers may be certified to do a polygraph examinations. However, the result of any such polygraph examination are inadmissible in all courts in this state. And that's Arkansas Code annotated. The proponent of the evidence bears the burden of proving by a preponderance of the evidence that the conditions of admissibility exist, and that comes from Foote. The burden will be difficult to meet here because the state's proposed evidence regarding alleged cell phone location is derived from data supplied by AT&T, which expressly warns that the data is unreliable. The records state the results provided are AT&T's best estimate of the location of the devices within the specified search. AT&T makes no guarantee as to the precise accuracy or volume of records provided. Please exercise caution in using these records for investigative purposes, such as location data is sourced from what?
As
Location data is sourced from various databases, which may cause location results to be less than exact. The suggestion that such data can pinpoint a device's specific location is unsupported, lacks the reliability required for admissibility, and amounts to nothing more than junk science. There is no accepted methodology that would support the opinions suggested by the state.
So I'm hoping they're going to tell us what those opinions are so that we can.
Yeah, they do.
Otherwise, okay.
Yeah, they do. I think when I was going through them, I saw that they had the actual slideshow.
I'll have to say that looks like a newer AT&T. Like their warnings have changed, or their little, what do you call those? Have changed over the years. That one I have not specifically seen.
I haven't seen that one either, and it's definitely more thorough than it used to be.
But it used to be like outgoing calls you can't use.
Yeah.
But all right.
So Daubert set forth 4 non-exclusive factors in determining reliability. 1, whether the technique employed or relied upon by the experts has been tested. 2, whether the technique has been subjected to peer review and publication. 3, the technique's rate of error, if known. And 4, whether the technique is generally accepted by the scientific community. And that's coming again, they're citing Foote, I believe was that case, right? The state has disclosed nothing related to the above 4 factors. As such, the state has provided no information demonstrating that the proposed testimony satisfies these reliability criteria. Courts have regularly required this information to be presented in court to permit the sitting judge to make a determination while performing the gatekeeping function. See State v. Edwards. Finding error in not holding a hearing to determine the reliability of the methodology for the law enforcement and officials' testimony concerning plotting the cell site locations on a map.
And that was a 2017 what? Federal or Arkansas? Connecticut. Okay.
Yeah. Okay. And then opining about the reliability of the testimony without a formal Daubert hearing, because expert had submitted 4 reports and prior testimony on the subject matter. And that's the Connecticut case.
No, that's the Jones case.
Where did you see 2017,
Go up.
by the way?
Go up. No, you're going down. There you go.
Oh, okay. Okay. All right. Courts throughout the country have noted, I've got it blown up, so because I can't read it otherwise in front of me. All right. So courts throughout the country have noted significant issues with using cell phone records to divine cell phone location. As the Missouri Court of Appeals noted in State v. Patton, it is impossible to determine from historical cell site data alone that a phone was closest to the cell site processing the call. And at best, these records only indicate that a phone was located somewhere within a cell site's geographical coverage area. A cell phone may be in range of several sites simultaneously, and a multitude of factors influence which site among them will have the strongest signal. The technical features of the cell site, geography, and the workings of the cell phone itself may result in connections from as far to which a phone connects permits an expansive range of inferences as to where the phone actually is. All right.
And then now note, that was also a 2013 case. So I'm hoping we're going to get some more
current
patent. Yeah. So something I was hoping to see something that says that this issue has arisen in recent years since this type of information has been allowed in previous. But here they are only using historical cell phone information. And that I've always thought there's been an issue with that, but courts have allowed it in so many times. But so far they're at least laying the legal framework for the fact that this has to be there has to be a hearing, especially with that, warning on the.
Yeah, and I think that part of the problem that has existed in terms of when this kind of data started being allowed into courts is that they didn't realize at the time when they were allowing it in just how
Varied it is, right?
So it's like now they're trying to undo the shit that they did by allowing it in on the front end, thinking it was more
Reliable than it is.
was, right. So while the large geographical area that a single cell can cover diminishes the probative value of the cell identification technique, perhaps the biggest drawback of the technique is that the cell phones can be associated with cell sites that are not even in close physical proximity. This is because cell phones connect to the cell site with the strongest signal rather than simply connecting to the closest cell site. Among the factors affecting which cell site a phone connects with are: one, the number of available cell sites; two, whether maintenance or repairs are being performed on a given cell site; three, the height of the cell tower; four, the height and angle of the antennas on a cell tower; five, the range of coverage; six, the wattage output; seven, the call volume at any given time and the call capacity of a cell site; and eight, environmental and geographical factors such as weather, topography, and the density of physical structures in the area. I mean, that's like some pretty good fucking law from Mississippi there.
Right.
It kind of digging into the exactly the type of shit that can really affect. They do keep putting cell site CITE instead of
I mean, there are cases where you can get real-time location data where they're pinging your phone, and that's different than using historical location data just from your phone bill, and that's the distinction that they are making here.
Yeah. All right. So even the PowerPoint presentation itself makes clear that the information contained within it is unreliable. Let me shrink this down here.
I just wonder what they're trying to keep out. What
We're going to get to it.
Okay.
Patience, young Jedi.
Patience, yes.
Okay, the presentation notes that the phone's call records and the list of cell site locations are, quote, used to illustrate an approximate location of the target cell phones for the network interactions. See attached PowerPoint slide 2. See, it's there. Attached as Exhibit A. So further, the presentation notes that the analysis is based upon and relies entirely on cell site location information, CSLI, provided by the service providers and or the National Domestic Communications Assistance Center, and then see Exhibit A. So further, do you want me to go to A?
Well, no, because what I'm looking for is what they're trying to say about what is the facts that the state's trying to put forward with this information? What are they trying to establish with it?
Well, I mean, I think I don't know if they're going to get into that here, but I mean, they gleaned it, or we were able to glean it from the last filing that we went through, where they were talking about where Aaron was when he's making texting and making calls. They're putting him at certain places. Okay, so
yeah, let's look at Exhibit A then, or was that it? That little picture.
I don't know if that was it. So we'll wait. I don't know if that was it. Further, the presentation notes that typical cell towers are configured with each sector covering approximately 120 degrees. See attached PowerPoint slide 4, attached as Exhibit B. However, the sector orientation can vary by cell site and service provider, Exhibit B. The presentation notes that, quote, a sector illustration shows the general area of coverage as it relates to a specific geographic area, and that, quote, neighboring cell sites aid in the estimation of coverage areas for each respective sector. So emphasis added where they they added the italicized it. So the presentation notes that the cell phone at issue, quote, will generally be located within the shared arc, but might be located closer to the tower than the depicted arc distance. See PowerPoint slide 5 attached as Exhibit C. A murder case is no place for maybes or mights. Agreed. So what is known about using cell site analysis to postulate cell phone location is that there is no way to pinpoint a cell phone's precise location from historical CSLI, and there are no known validation or error rates for the methodologies used to collect and analyze the data. So see Victoria Sachs, junk evidence, a call to scrutinize historical cell site location evidence.
There you go. Something from 2020.
Yep. It's getting more recent, babe. The accuracy of the underlying, excuse me. The accuracy of the underlying data provided by the cell service providers is unknown. Rather, the data being analyzed comes from unvalidated records of cellular network operations and unvalidated information about cell tower locations collected by phone companies for network billing purposes. There has been no validation of the cell site data provided by the phone companies either. And then again, citing that
2020
treatise.
law review.
Further, this analysis relies on the admitted fallacy that cell phones always connect to the nearest tower. Even at a cursory review that counsel has been able to do between receiving the PowerPoint from the state on Thursday and Monday, when the motion is due, the PowerPoint appears to contain erroneous information about the process and its functioning. The report and conclusions also appear to include and rely on data that has not been provided to the defense. The report also suggests, especially through the maps and diagrams, that this data can precisely pinpoint a phone's location as inside or outside of an area when that is entirely impossible. It is one thing to use cell tower data to determine whether a phone is in a certain part of town or in one city versus another, but this data cannot provide reliable evidence as to where a person was within a several mile radius at an exact point in time. Generally, when this type of evidence is admitted, the opinion is far more broad, so the data may be reasonably reliable for that purpose. But here, the data simply cannot substantiate any opinion of Spencer's exact location at an exact moment, and therefore admitting it has no legitimate purpose other than to mislead and confuse the jury as to the reliability of other evidence presented. The produced report paints a misleading and inaccurate picture as to precise locations and oversimplifies what is a complex assessment. Most significantly, the images depicted in the report are highly misleading. For example, it suggests that the signal from a cell tower propagates strictly in a 120-degree wedge. See PowerPoint 4. In real world, however, cellular antennas radio frequency coverage consists of main lobes, side lobes, and rear lobes, as illustrated below using the radio planner, tool employed by cellular companies for network planning. The depiction of coverage is not as simplistic as a 120-degree wedge. On the left is a real radio frequency plot overlaid with what the state report depicts, which is to place a 120-degree sector shown in red lines. On the right is from the FBI's training manual. In real world, the defendant could be as far as Ferndale, which is the opposite direction for the FBI manual relying on a 100-degree wedge is pointing. All right, so can you guys make these out? So that's the wedge on this one. And you can see the actual coverage area.
Is in blue?
Yeah. And then over here.
So the FBI is using this similar wedge thing without going back at all.
What do you mean?
Like it's, I don't know if this is facing and the top is north. So assuming it is, the FBI isn't capturing anything west of that.
Right. That's why they were saying it could be all the way in Ferndale. Like the person could be actually in Ferndale if you're to look at that kind of blue blob there in terms of actual coverage area. All right. So moreover, The data provided with the report does not appear to include all data used to formulate the theories in the report, as there is data that cannot be matched to the data provided. The defense has requested and is entitled to the underlying data. Not only does the omitted data raise serious concerns about the accuracy of the report, but at this late point, Spencer objects to production of more data and asks for the testimony based on undisclosed data to be excluded. What the data does accurately show about Spencer's movements in the area is already known. So adding this testimony that does not contradict the other information but presents speculative possibilities inserts confusion into the trial, may mislead the jury, and certainly creates prejudice. And because it cannot provide reliable information about precise location, it provides no relevant information for the jury's consideration. As the gatekeeper, the court should not permit evidence that lacks specificity and reliability and which lacks any real probative value. So Spencer requests that this court make specific factual findings on Daubert factors and the following issues. One, the court should not permit any additional supplements of data and should instead exclude this expert testimony at trial for this reason and all other reasons herein in the accompanying brief in support. That this court should conduct a hearing, which is it considers evidence relevant to where'd she go? Had she left? Where were you?
Accidentally did that swipey thing.
Oh, okay. So the court should conduct a hearing at which it considers evidence relevant to Daubert analysis and should thereafter exclude the evidence as unreliable. And then 3, should this court find that the proposed evidence satisfies the requirements of Daubert, it should still be excluded as hearsay, lacking a proper foundation, speculative, and violating Arkansas Rule of Evidence 403. All right, let's see.
Which means it's more prejudicial than probative.
Yes. Okay, 4, the state's witnesses certainly should not be permitted to show the jury a diagram or present any testimony that purports to show definitively where a person's cell phone was located at a particular time. This data simply cannot support that kind of certainty. 5, the court should find that the underlying records are inadmissible pursuant to Arkansas Rules of Evidence 803-6, as they are not generated during the course of business, but rather in response to requests from law enforcement. Further, there has been no foundation laid showing how the records were produced, identified, and or stored. What may be sufficient for the business purposes of cell carriers is not necessarily reliable for the purpose of proving a defendant's location in a criminal case.
Right. So 8036 is the business record exception to the hearsay rule. If it was, if it's a certified record that's done for business, and they don't need to in the normal regularly conducted activity in the normal course of business, then they don't need to like have somebody come and or it can get around the hearsay exception, and they're saying that they should not be allowed to use that in this case.
Yeah, I mean, obviously, first and foremost, they're asking for a hearing. Well, they're frankly just asking for to bar it based on the brief. But then, in the event that doesn't work, then okay, well, then we have to have a Daubert hearing. So the court should find that even if the evidence is relevant, which Spencer does not concede, any marginal relevance is substantially outweighed by the very real dangers of confusing the issues, misleading the jury, and unfair prejudice. Jurors have been shown to overvalue forensic evidence in a way that makes them more likely to convict based on misinterpretation of that forensic evidence. Bless you. And that comes from John Aldridge, The CSI Effect and Its Potential Impact on Juror Decisions. That was a 2015 treatise. There is a very real threat that jurors interpret this evidence as affirmative proof of Spencer's precise location, despite numerous disclaimers about the reliability and the accuracy of the evidence. That is the definition of unfair prejudice. So this court must exclude any evidence purporting to pinpoint the location of Spencer's cell phone on the morning of October 8th of 2024, including the PowerPoint presentation at issue or any part thereof. Okay, so
presumably the defense will have their own expert lined up to say why the evidence can't be trusted. But it might be something they can keep out, given that warning that AT&T gives.
Yeah.
So is that the guy's CV?
I don't know. It looks like a CAS document. So you're right there,
It's the
kid.
PowerPoint.
Yeah, this is the PowerPoint.
I might have to leave you soon.
Why?
It's hot as hell down here. I'm all bundled up with this damn sling, and I have this heavy sweatshirt on that I can't get off. And
okay, so let's go through this quickly. So this is presumably what the state would be looking to present at trial. So you got, it's got the official Department of Justice logo up there, and you got the CAS thing over here. It's a real official looking document, right? So the background, the FBI Bureau of Investigation Cellular Analysis Survey Team, CAST, was requested to analyze cell phone records for 501, 259, blah, blah.
All right, we get that. We can skip background at that point.
Okay, so target cell phones. The target cell phones are believed to be associated with a homicide, which occurred on 10/8 of 2024. Methodology and analysis was performed on cell detail records and timing advance records.
Now, I don't know what timing advanced records are. Huh.
Obtained for the target cell phones. I don't either. So the CDR and TA documented the network interactions to and from the target cell phones. Additionally, the CDR and the TA documented the cell phone, the cell tower and cell sector or cell site, which served the cell phone during this activity. And the TA also documented a calculated distance measurement for the target cell phones from the serving cell site. Used in conjunction with the CDR TA and a list of cell site locations, will be used to illustrate an approximate location of the target cell phones for network interactions. So 2.1 cell site location. Cell sites in existence during the time of the incident were loaded into mapping software using the latitude and longitude coordinates of the cell site provided by the service providers and or the National Domestic Communications Assistance Center. Cell sites associated with the target cell phones were located utilizing the mapping software and the plotted cell site data.
All right, so just so you know, timing advanced records is a type of cell phone data that measures the delay in a cell phone signal to estimate its distance from the tower. So this is stuff that law enforcement gets and cell phone companies use, and it's supposed to help pinpoint, a device's location.
Okay. Thank you for that. DB had said the exact same thing in our chat.
Oh, sorry.
I didn't see it either. I've got the thing so blown up.
Me
All right,
too.
so conclusions. A historical, let me see, I gotta blow this thing up again. A historical cell site analysis was performed on the call detail records for the target cell phones. The methods detailed in sections 2 and 2.1 were used to produce the attached historical cell site analysis maps. The analysis may not describe or depict all events listed in the call detail records. All right, so this is what they got going on here. Okay, so sectors and orientation. Typical towers are configured within 3 sectors. The center of each sector is identified by an azimuth. Is that how you pronounce that?
I don't know.
Azimuth? Seems like it. Compass direction expressed in degrees. Unless otherwise noted, each sector covers approximately 120 degrees. So that's that wedge that they're talking about.
All right, why don't we jump down to like what they're actually saying? Like what they're saying all this means.
Okay, so you don't. So this is the explanation. Do you want this?
Yeah, no, I guess so. For the timing advance thing, yeah.
Yeah. So okay, hold on. Like people can't see with the thing. Can you take that
I might
off?
have to come down and come up and change.
You do what you got to do, girl. Can you take that thing off for me? Like the border with the
Oh
I
yeah,
love due
I can.
process?
Yeah.
It's blocking the imagery. All right, so timing advanced explanation. Okay. So timing advanced AT&T, T-Mobile, and US Cellular or real-time tool Verizon. So a road trip network measurement from a tower to device and back, referred to as a round trip time, RTT. The device will generally be located within the shaded arc, but might be located closer to the tower than the depicted arc distance, not based on the tower with the best signal. So measurements can occur outside the usable coverage area for voice, text, message, and data activity. So yeah, I mean, like this is what they're talking about generally be located within the shaded arc, but might be located closer to the tower than the depicted arc distance. I mean, in this case, it's I know why they're filing these motions as they should, but the reality is I don't think any of this is going to hurt him, even if it gets in. To be honest with you, I mean, we all know what happened. You know, I don't know unless they're putting another theory out there that I'm not aware of in terms of where Aaron was, or they're going to try to say he was laying in wait somewhere, some other theory that I'm just not aware of. I mean, it kind of is what it is in terms of when he leaves the house, and he's chasing them for 6 miles and they ultimately end up where they end up. So I don't know. I don't know what their theory is going to be beyond like why they're trying to pinpoint them, why they think it's relevant based on the motion that we read. Like I'm not aware. It doesn't make it sound like there's a new theory. So, which is why they're saying it's not relevant. I mean, we basically know the story. Like, why do they feel like they need to try to pinpoint where he is? Like, if they're going to try to say that Aaron Spencer was, 15 feet away from Fossler and that they're able to get that information from this cell tower data, they're full of shit. I mean, you can't have them saying that. If they're going to try to bolster whatever their story of what happened that night is by using cell phone data and location data, they can't do it. It's just not accurate enough. Let's see. All right. So when displayed on a map, a timing advance illustration shows the calculated distance of a mobile device from the cell site based on a round trip time RTT measurement taken during a call, text message, data session, or other network. Neighboring cell sites do not have any impact on the calculated distance of the mobile device from the displayed cell site. So here again, you got that 120-degree angle, but as they put in the body of the motion, I mean, that's just not an accurate depiction of what's covered. I mean, if this is the reality, this thing here, then that fucking wedge is bullshit. You can't pretend that this other area that's outside the wedge doesn't exist in terms of coverage area. That's not the kind of shit you can bring into court as some kind of rock solid evidence of anything. All right, so that was the thing that Allison made me skip. All right, okay, so let's get down to 12. Okay, so this is 11. So this is sectors and orientation. Okay, can you guys even see that? Okay, so typical towers are configured with 3 sectors. This seems like the same thing that she told me to skip. The center of each sector is identified by an azimuth compass direction expressed in degrees. So unless otherwise noted, each sector covers approximately 120 degrees. All right, so they've got this fixture or this demonstrative here. So you can see there's a tower. Now this looks to be one tower. So it covers 3 different sectors. Okay. Okay, so active sectors are displayed as a wedge within the shaded arc. The shaded arc solely indicates the general direction of the radio frequency signal. The sector orientation can vary by cell site and service provider. Okay, so when displayed on a map, a sector illustration shows the general area of the coverage as it relates to the specific geographic area and indicates incoming or outgoing activity. Neighboring cell sites aid in the estimation of coverage areas for each respective sector. All maps are oriented to true north. Okay, so when displayed on a map, a sector illustration shows the general area of coverage as it relates to a specific geographic area and indicates incoming or outgoing activity. So neighboring cell sites aid in the estimation of coverage areas. See, that's the shit that they're talking about. So you've got neighboring cell sites are aiding in the estimation of coverage areas. Nah, that ain't it, man. That ain't it. All right, so is this the same thing that I just went through? Oh yeah, what the fuck? All right, so I think that was it. I think I just went through the shit Allison asked me to. All right, so that's basically it. So, you know, if the judge is anything like me, I mean, this is exactly why I hire experts at trial. You know, I am not an expert in cell data location and the records that you know come along with that, to the extent where, you know, I could argue authoritatively about anything. That's why you hire experts to explain this shit to you. Azimuth, yeah, that's what I said. I had it right. All right, so I have a feeling. I mean, if I don't have any kind of hope that the judge has a firm knowledge base on this stuff either. So, which to me means that she's going to need to have a Daubert hearing. I mean, if she rules on it off the cuff and just allows it in, that's crazy. That's crazy. Because like I'm really curious as to what Allison was saying. Like it's the thing that she wanted to know. Like what are they implying? Like what are they trying to demonstrate by bringing this evidence in? Like what is their theory in terms of why this is relevant? Why does this become important when we, again, for the most part, know the facts of the case in terms of where people were at certain times, without having to try to pretend like we can geolocate them, you know, to the foot. I don't know. How you doing there, pal?
All right.
Dude, you could dip. Like you
No,
seem
I'm better.
miserable. You sound miserable.
No, I'm better.
A lot of sighing. All right. Okay. I mean, I'm doing all the heavy lifting. You're really just kind of sitting there.
I know.
I know. All right. So that's that brief. Okay. So this is another brief that was filed. Okay. Again on the 24th. So what do you think is going to happen with that? Like, what do you think the judge will do with that?
I mean, I don't know, because a lot of times they're like, this stuff has been getting in all the time. You know, you bring on your competing expert, deal with it that way. It's been satisfied to under Daubert, the methodology, you know, but they have brought up some different points. That is different information than AT&T has provided in this way. So I do think that they would get a Daubert hearing.
Yeah, I mean, DB's of the opinion that there's no way it doesn't get in, just because the FBI, you know, has a whole team that testifies all over the country on cases with timing advanced data. So, I mean, if that's the case,
I know, but I've seen courts say this is not a Daubert issue. It's been getting in courts all over the place. This is a, you know, like a dispute. But I mean, I agree with DB that there should be a Daubert hearing, especially given that.
Well, he's saying, presuming that there is a Daubert, that it's getting in, that the judge will give so much weight to the feds.
Oh, he's saying that no way it doesn't get it right. So then I do agree. I agree with him on that. That's why I think that they are going to. I thought you were saying that DB said there's no way it doesn't get a Daubert hearing.
No,
and
no.
I don't even know if she'll grant a hearing because of the fact that this gets in all the time. And it sounds like this TA data is something different. I don't think that they explained it well. Like, I was listening to what you were reading, this timing shit. They didn't explain how that's any different than the information they're already getting from just the historical cell site information from the cell phone records, which is different than real-time location information.
Yeah, I mean, I think if it's going to be getting in, that there's going to have to be like a curative instruction regarding it in terms of exactly how reliable it is. You know,
I
because
don't think
if they're,
I
I
don't think
mean,
they're gonna
well,
get that.
but then it's bullshit. If they
It's
can,
that
if
it's
they're going to
what
be
you do with
trying to,
cross-examination.
yeah, but it's like, how many people in the chat do you think fucking understood what any of this shit meant? Like, you have to, you're talking about like
Probably some
Lonoke
people
County,
more than us.
probably. I mean, but you know, you can't assume that 12 people from Lonoke County are going to have any idea what this shit means. And it's like that CSI effect thing is real. You know, people are just going to give it more weight. Like, but then again, I don't know what they're trying to use it for.
Right.
Like, that's the thing.
It's what you're saying, that they're gonna say he was at this place when he picked up the phone and looked at a message or texted his wife or called his wife, whatever the hell he's trying to do.
Yeah, so I mean, we'll have to see how that plays out. I mean, based on the motion, like, it doesn't sound like they're trying to come up with some kind of crazy theory beyond what was already kind of out there, which is
I do think that this is somewhat different. I mean, we sort of had this issue in Reed, but they were using other data, not just historic cell phone data from the call detail records. They were using the health data, the this, the that, to like pinpoint it. And so what I do think is different here is how that they're trying to literally pinpoint him to a specific location, as opposed to, you know,
right. And why?
right.
Like, why? Like, what? There has to be some theory that they've cooked
I mean,
up.
I was trying to listen while I was changing, but I didn't hear.
No, they didn't. Like, she didn't get into it.
No, I mean, but that report, their report doesn't seem to spit out any. And from this data, we can say he was here at this time, at that. Like, they didn't do that, right?
No,
right.
Not at all. There was nothing specific to Aaron or his phone. Like, they reference it.
Right.
They put his phone number on blast, but then there's nothing in the actual report that gives any location whatsoever, unless it was that one particular, you know, kind of wedge that they showed with Ferndale or wherever that one town, the neighboring town was.
We're gonna take a pause in these announcements to say happy birthday to Sandra McCarthy's twin grandkids, Samantha and Wyatt. McCartney.
Aw,
sorry.
Happy birthday, twins.
Samantha and Wyatt.
That's so sweet. Samantha and Wyatt. So you guys born the day before Thanksgiving, huh? Cool.
Well, Thanksgiving changes all the time, but they probably were very close because Courtney was born.
Yeah, that's true. She was the 24th.
So she was the actual.
Well,
when she was born, I think
sometimes
Thanksgiving was.
Yeah.
Yeah, it's the third Thursday of every. Right? Am I making that up?
No, I think
is it something like the Thursday?
I think it might be the last one.
Oh,
the last Thursday.
Is it always a Thursday? Now I feel like
it's always a Thursday.
Okay, all right. So it does change. Okay.
Yeah, but the
oh my God! Rewind, delete, please.
All right, so this is another motion that was filed.
And I think we can summarize this, right? That they're asking to. Or go ahead. Do you want to read it all, or?
I mean.
So they're asking the court to conduct voir dire in like small groups outside the presence of the whole panel, either individually or small groups. And they do that so that one person's answer does not pollute the entire panel. Yeah. So go ahead, jump to the crux of it there. Spencer is charged with.
All right, so Spencer is charged with second-degree murder with a firearm enhancement. The case involves the killing of Michael Fossler, who essayed Spencer's daughter and who, despite facing 40 pending felonies related to that abuse, picked her up in the dark of night to continue victimizing her until Spencer intervened. Spencer has raised justification defenses, including that he reasonably believed Fossler posed an imminent risk of harm to Spencer's daughter and to Spencer himself, and that the force used was necessary to avoid that harm, citing Arkansas Code. So the subject matter of the case,
essay of a minor,
parental defense of a child, and the questions whether Spencer's use of force was justified alone warrants individual or small group voir dire. Prospective jurors are likely to hold strong personal beliefs, about essay, parental protection, and self-defense. Both parties will necessarily explore these topics.
I have to say, in this factual scenario, I feel like it's the state that should be asking for the individual voir dire, because I think what most likely people are going to say is you protect your child at all costs at that, no matter what. I don't think they're going to be like saying things that would prejudice the defendant in any way, shape, or form. But I mean, I guess it's possible.
Yeah. All right. So because these issues are deeply sensitive and highly charged, jurors may influence one another's views during group voir dire, or hesitate to share their true feelings in front of dozens of community members, which is so true. It's like jury duty is like no other kind of experience that you have in life. It's just such a different, strange thing. And it's not something that you're accustomed to. And, they're asking questions of you as you're sitting there, and, people that aren't, real talkative or are not real open about sharing private shit,
Maybe the jurors are worried. Maybe the defense is worried that enough jurors will say something like, I don't care, you kill that MF or no matter what, that they'll get too many jurors agreeing with that. If it's in a group setting, and then they'll lose a bunch of jurors because one juror will say something outright, and then other jurors will be like, yeah, I feel the same way. And then they'll be like, lose jurors that might not have otherwise spoken so openly
about,
I don't know.
And that problem leads right into that whole issue that the state keeps trying to make this seem like a vigilante thing when it's not.
Right.
Because that statement that you just said is some vigilante shit. Like,
Right.
I don't give a fuck.
Right.
Put him down. Put that motherfucker down. And you want those people on the jury.
Right. But if you're talking about a fair, if you're looking at it objectively, not from the defense standpoint, right? The prosecution should want to weed those people out to get a fair jury.
Yeah. Well,
But it might be the motivating factor for the defense filing a motion like this. Like, I don't want everybody expressing how much they could give a shit less what he did to this person because he deserved whatever he got, so that they don't lose too many jurors and gets.
Yeah, because you're getting bounced for cause on that shit. Right. The state's not going to even have to use any kind of peremptory on that. It's like you're just gone. Cause.
Right.
You need the state. You need to be forcing the state to use all their challenges. So don't worry. When I go down for my boots on the ground shit, I'm going to talk to all the prospective. No, I'm kidding. Hey, when you're in the voir dire, just don't say any crazy shit about vigilante shit. Okay, just keep it to yourself. All right. The case has also received public attention due to its subject matter and because of prior proceedings included review by the Arkansas Supreme Court. In addition, several individuals connected to the events live in Lonoke County and may be known to potential jurors. Members of Spencer's wife's family and Fossler's family have deep roots in the community. Both Spencer and a key witness, Sheriff John Staley, are candidates for public office, adding further publicity. These circumstances increase the likelihood that prospective jurors have been exposed to extrajudicial information or hold strong opinions that could influence others if expressed in a group setting. Now,
so that might be, something they're afraid of, that someone's going to pop off about not liking Spencer for this, that, or the other, or knowing him to be this type of person, or no,
Yeah.
so that could be a fear for sure.
Well, yeah, and that's, that's like the thing that you worry about with Aaron running for sheriff. I mean, people may have certain feelings about that. You know what I'm saying? Um, wrong, right, or indifferent, it doesn't matter. People may have feelings about it, and you have to be cognizant of it. And, some people will be like, oh, well, now's not the time to be doing that. Well, I mean, that's your opinion.
So that might be more of the motivating factor here. They might be concerned that people who know them, know the family or whatever, are going to pop off about whatever and then taint the rest of the jury pool.
Yeah. So a more searching inquiry is possible during individual or small group voir dire. Complete and candid answers are far more likely in that setting than in large group questioning. Individual questioning is essential to identifying biases or preconceived opinions, free from the risk that jurors adopt answers that they have heard others give, conform their responses to group expectations, or avoid expressing sensitive views in public. Now, this goes to that thing, like one of the first questions Allie always asks prospective jurors is, can you hold the line? Like when they're coming at you, if you're the one, and there's 11 coming at you telling you fucking need to change your shit, can you hold the line? Hold. You have to be able to hold your position. You're not going to cave under the pressure of 11 other people coming at you hard as hell. That you'll stand firm with what you believe.
If you still feel that way after fairly deliberating, fairly hearing both sides.
Right.
So I think that I don't know that we need to read the rest of this.
I'm reading the rest of it.
Okay.
It's interesting. So, and it's not long. It's almost done. We've just stopped to talk a little bit. Okay. So moreover, when prospective jurors explain that they have heard about the case, they often repeat details that may be inaccurate, inflammatory, or inadmissible. Doing so in front of other prospective jurors risks training the entire panel.
I think it's supposed to say tainting.
Tainting, yes. It is crucial to determine what prospective jurors know about the case, what opinions they hold, and whether they can set aside that information and decide the case based solely on the evidence in the law. Conducting that inquiry in the presence of the full veneer, however, risks contaminating the panel and jeopardizing Spencer's right to a fair trial. Counsel cannot meaningfully explore these issues without individual voir dire. And it does take longer. It really does. I mean, when you're having to do it individually, it's going to add a day, maybe 2, maybe 3, depending on the size of the veneer.
But it should be granted.
It should be granted because I mean, that's what we had to do we individually did it for Garcia, and it took forever. It took days, but we brought them each in because it was high publicity in that area. Everybody knew about the case, and we had to make sure, even though it was bullshit, the curative thing that the judge said, well, I understand that you think he's absolutely guilty and he should burn in hell, but can you follow the law and the evidence? Oh, yeah, I can do that. Yeah, sure, pal.
Okay, I'm not striking him for cause. If you want to use one of your strikes, do it.
That's how it goes. So the United States Supreme Court has long held that a juror must render a verdict based solely on the evidence presented in court. And then the right to an impartial jury necessarily includes the right to take reasonable steps to ensure that impartiality. And then Justice Marshall concurring in part and dissenting in part. Voir dire is the mechanism by which challenges for cause and peremptory challenges are made meaningful. So without a full and adequate voir dire, these rights are illusory. So courts have recognized the importance of individual voir dire in cases involving substantial publicity or sensitive subject matter. And they're citing cases here. So affirming, and when they cite cases and they're plucking the language out.
Right. And this is a U.S. Supreme Court 2010 affirming that individualized voir dire to prevent jurors from influencing one another with prejudicial information.
Yeah. And so the ABA standards for criminal justice likewise recommend individual examination when exposure to prejudicial material is likely. Okay. So for these reasons, they're asking the court to adopt procedures for voir dire that will allow full and complete voir dire of jurors, but also provide reasonable assurances that prejudices will be discovered. Individual or small group sequestered voir dire. Like, I don't even like the small group. I think you still have the problem.
Right,
with,
but then you're only tainting a small group. Like, if they're talking like 4 or 5, 6 people, then I mean, 6 is a lot. I don't know how many people that they pulled for this jury.
I don't know. That's what I'm saying. I don't know what the size of the veneer is. I'm assuming it's going to be bigger than usual.
Right.
So in this case, individualized or small group sequestered voir dire is necessary to safeguard Spencer's rights under the 5th and 14th and the 6th. Okay. And the 14th, equal protection under the law, as well as the corresponding protections of the Arkansas Constitution. So it's an important motion.
Likely will be granted.
I think it should be granted because both sides want a fair trial, right? I mean, that's the thing. Okay, so if you'll remember way back when, there was a motion in limine by the defense that was filed to exclude reference to this alleged glass smoking device that was found in the cop car that Aaron Spencer was placed in.
Right, that Aaron insisted was already in there when he was placed in there. They like put him in, they took him out, then they put him back in, and he's like, "Hey, yeah, whoa, there's some shit
Hey,
back
brother,
there."
there's a bowl in here. Somebody was smoking a fucking bowl in the back of your cruiser here, man, and it wasn't me. Wasn't me, bro. All right, so this is the state's response to that. So John Huggins, for response to the defendant's motion in limine to exclude evidence, states the state agrees with the defense in their motion in limine that no reference should be made by either side of the glass smoking device found in the floorboard of the cruiser in which Aaron Spencer was detained after his arrest. Arkansas Rule 401.
All right, so there you go.
States the relevant. Yeah. All right. So there you go. They conceded on that one. So the
glass
smoking
out.
device out. No mention of that. Okay. So this is another shorty. So the state has now filed a motion in limine to exclude background.
Didn't you do this already? Yeah.
Did I?
Oh, is that the brief in support of the motion?
No.
Wait, to exclude the evidence that he didn't know of. That. Let
me see.
It's their motion
to exclude facts not known. It's different.
Oh, okay.
I mean, it sounds like basically the same. All right. So state's motion eliminate to exclude 2 times. To exclude background facts not known to see. This is what happens when you're rushing to get motions prepared.
It seems like the same fucking motion.
It seems like the same.
How long is it?
47 pages.
No, you're kidding. What is it really?
I am. It's 2 pages. So background facts not known to Spencer at the time of the offense pursuant to rules of evidence 401 and 403. So in Spencer's response to state's motion for gag, the defense alludes to information suggesting that Fossler was known by others in both Arkansas and other states as being sexually depraved. Information that was unknown to Spencer at the time of the shooting is irrelevant. In order to ensure fairness and avoid the risk of confusing the jury, and the state respectfully moves to exclude any evidence of Fossler's character that was unknown to Spencer at the time of the shooting. Now, just a ponderable here. Do you think that it's possible that Aaron and Heather may have been asking around? Like, yes, hey, what do you know about this fucking spy? Like this guy, especially when he's let out on $5,000 bond.
Oh yeah. There's no chance in hell somebody abuses your child and you're not digging around, searching around, asking around for every possible bit of information on this person. So he may have known a lot.
Right. You don't think Heather got on fucking line and started Googling Fossler like immediately?
Right.
like this fucking creep.
And and all he needs to say is what he knew. How are they going to prove he didn't know it?
Right. I mean, how can they prove it? All right. So argument, any evidence of Fossler's character unknown to Spencer is inadmissible. So evidence of a victim's alleged violent character is not admissible if the defendant was not aware of it at the time of the killing, and that's Sims v. State. So facts about Fossler that were unknown to Spencer at the moment he pulled the trigger could not have influenced his perception, his state of mind, or the objective circumstances of the encounter. Such evidence is therefore irrelevant and carries a substantial danger of confusing the issues, inviting speculation, and diverting the jury into collateral mini trials.
So how is this different than jump back to the other one? Because
let's see, the other one, I think this was it. It's basically to say the state moves of the defense be prohibited from eliciting any testimony or presenting any evidence regarding prior misconduct by Fossler that Spencer did not. I mean, it's essentially the same shit.
It's even entitled the same thing, background facts not known. So
yeah,
I think this is more like their brief in support. They just didn't call it that because it had like a conclusion and an argument. I don't know.
Yeah, I mean, but to that point, like, how do they fucking know what Aaron knew or didn't know? It was 3 months, and this creep was lurking about out in public. I'd be digging into him, I'll tell you that. I'd be finding all out about that guy. All kinds of shit. All right. So this is a shorty, babe. You'll be happy to know. State's response to the defendant's notice to raise justification as a defense. Okay, so the defense has provided notice to the state and this court that it intends to raise justification as a defense under the code 5-2, 604, 606, 607. Arkansas case law holds that 604 or the choice of evils defense should not be given where self-defense and presumably defense of others is also argued by the defendant. So state objects to the defense arguing the choice of evils defense if it also argues self-defense and or defense of others. So you know what you need to do right now? Yeah. Look up that, find me the choice of evils defense. I want to know what it is. Okay. So now this one seems the exact same thing. This seems like so this seems duplicative. The subject matter essay, sharing true feelings. There is more than average public.
In the meantime, why don't you pull up, because I saw it. They amended their affirmative defenses, but so look for that while I read this. In Arkansas, the choice of evil. Let me see. I'll just read it from here.
Yeah, this one's substantially similar to the one that we just
All right, but look for the.
Damn, girl, you got to hit that cough button.
I'm sorry. The defense filed an amended justification notice.
Okay, I'll get to it. Like,
all right, well, look for that while I read.
I'm just saying, I got 30 things.
I know, but it goes in. I'll pull it up then.
All right, wait. What do you want it to be? What is it?
It's the defense's amended justification defense.
Okay.
And in the meantime, I'll read this 604. Conduct that would otherwise constitute an offense is justifiable when 1. The conduct is necessary as an emergency measure to avoid an imminent public or private injury, and 2, according to ordinary standards of reasonableness, the desirability and urgency of avoiding the imminent public or private injury outweigh the injury sought to be prevented by the law prescribing the conduct. Justification under this section shall not rest upon consideration pertaining to the morality or advisability of the statute defining the offense charged. If the actor is reckless or negligent in bringing about the situation requiring a choice of evils, or in apprising the necessity for his or her conduct, the justification afforded by this section is unavailable in a prosecution for an offense for which recklessness or negligence, as the case may be, suffices to establish a culpable mental state. So, apparently the law, as at least the way the state has outlined it, indicates you can't rely on 604 if you're also relying on an affirmative defense of others or self-defense. Now that we'll just have to see how the briefs play out with that, because I haven't researched that issue at this point.
Okay.
So is that it? The amended?
No, I think. Okay, here it is. All right, so here's the. See, I didn't get to hear what you were reading though because I was looking for this thing. All right. So comes now the defendant, Aaron Spencer, buying through his
Oh,
attorneys
there you go.
and his
He
notice.
he
Huh?
takes back they take out 604. They say they're not gonna rely on it.
Okay. So the defendant is charged with
Oh, no,
felony
they do.
offense.
Sorry.
The defense does intend to raise justification as defense under Arkansas Code 604 and 607 in the above referenced case. Defendant is hereby giving notice to the state and the court. Wait, are 604 and 607, is that self-defense, defense of another?
No, that's the choice of evils. I thought it said does not intend. So the 604 is the defense of others, and the 607 is, let's see. Hold on. 60 607 is use of deadly physical force in defense of a person.
Okay, so that's defense of another.
Right.
Okay, so where is the
604 is the choice of evils.
oh, okay. So what was it again? Like just brief it for me. You don't have to
That you
read.
can that if they're taking action to avoid a greater harm and it's not reckless or negligent, then that's a defense.
Okay. All right. Well, do you think the state's brief holds water?
I don't know. Because that's what I said, is that I haven't researched that issue of whether there's some limitation to using 604. I can't imagine that the state just made it up, but I can't also imagine that the defense doesn't know that they can't rely on both defenses. So we'll have to see once these get briefed out.
Okay.
And I don't know what happened to, why is she only mentioning 6004 and 607?
Well, does 607
Like what
include
happened to
self-defense?
606? No, it looks like 607. Well,
Okay.
maybe. Let me just say. Oh, okay. So 606 is defend himself or another. 607 says a person is justified in using deadly force upon another person if the person reasonably believes that person is. So I guess that would be on him or another person committing or about to commit a felony involving physical force or violence, using or about to use unlawful deadly physical force, or imminently endangering the person's life, or imminently about to victimize the person from the continuation of a pattern of domestic abuse.
Okay. All right. Yeah. I mean, that's going to have to get briefed out. I mean, if it like the states, I mean, kind of definitively saying that it's a one or the other proposition, that you can't do both, but I don't know. All right. So this is the defense filed another motion, which was for renewed motion for discovery.
Sorry, mute.
Yeah, we're a little late. All right. So the defendant filed a motion for discovery in this case on January 2nd, 2025. And an amended motion for discovery and brief in support on November 20th, 25. The defense is aware that the state compelled at least one, if not more, witnesses to attend interviews in connection with this case. The defense has not received any materials in discovery referencing or pertaining to these interviews. The defense requested the court order the state to identify and provide any notes, memoranda, or other documents related to these interviews. This information is material to preparation of the defense, particularly because there is a very limited information in the interviews previously produced by the state. The state must also provide any information derived from those meetings that may be exculpatory. This includes production of all documents, statements, reports, notes, or other evidence favorable to the defendant on the issue of guilt, including that which affects the credibility of the state's case or constitutes potential impeachment material, and which is relevant to either guilt or sentencing. And that's Brady. Okay. Okay, so we saw that one. All right, so that's glass smoking device.
I couldn't wait, so I'm researching it right now to see if I can find anything about this using both defenses at the same time.
Okay. All right. So state's notice of expert witness disclosure. So the state of Arkansas, by and through Chief Deputy Prosecuting Attorney John Huggins, serves notice of intent to potentially call as witness the following experts. All members of the Arkansas State Crime Lab who have conducted analysis and findings in this case and have been provided to the defense through discovery. So Jason Dooley, Arkansas Statey, Blake Downing, FBI, and Amber Calmer, the Arkansas Attorney General's office. So that's them giving notice as required. Okay. All right. So to exclude evidence of expert testimony. Okay. So did they file this with a quickness, like right after they got that? Okay. So this is filed by the state. Okay. And this is their response to in support of the state's amended motion in limine to exclude expert testimony. States the following. So introduction, Spencer's defense counsel served notice of intent to call 3 expert witnesses at trial. Okay, so this is the thing with the psychologist or the psychiatrist, the people that we're going to talk about abuse, all that shit that we had that big debate on the last live. Okay, so but if you're not remembering, she's not listening anyway.
No.
So Spencer's defense counsel served notice of intent to call 3 expert witnesses at trial. The notice consisted solely of the expert's curriculum vitae or their resume, previously filed as composite exhibit A to the state's earlier motion. The disclosure contains no information regarding the subject matter on which each expert is expected to testify, the substance of the facts or opinions to which each expert will testify, or the grounds or bases for these opinions. No supplemental disclosures have been provided. So argument, Arkansas Rule of Evidence 104A expressly authorizes the trial court to decide preliminary questions concerning the admissibility of evidence, including the qualifications of a witness and the admissibility of expert testimony. Such determinations are routinely made pre-trial when the reliability or relevance of expert testimony is at issue. Hoyle v. State, approving pre-trial Daubert hearing in a criminal case. Arkansas has adopted the Daubert standard, which we know from the last memo that we read. As far as reliability of testimony, we know that comes from Foote. And then Coca-Cola Bottling versus Gill, extending Daubert v. Combo Tire v. Carmichael to all expert testimony, not merely scientific. Oh, I lost my shit.
All right. Well, by the way, at least according to this Supreme Court case, Supreme Court of Arkansas. Hold on. Our daughter's going through a crisis.
Yeah, just don't have her coming home without that shit resolved. It's the last thing we need. It's a flea situation with her friend's new puppy. Nightmare. Don't be bringing fleas to our house. I'll tell you that. What? I don't know if she's sick. She might be. I don't think so. She's sick of that shoulder thing. I'll tell you that. All right. So to all expert testimony, not merely scientific, before any expert may testify under Arkansas Rules of Evidence 702, the court must determine that the testimony is both relevant and reliable, and that the reasoning or methodology is valid and properly applied to the facts of the case. Without disclosure of the expert's opinions and the facts, data, and methodology supporting those opinions, neither the state nor the court can perform the required Daubert Rule 702 analysis. Even if the testimony ultimately proves reliable, it still must be relevant under Arkansas Rule of Evidence 401. Evidence having any tendency to make the existence of any fact that is of consequence more or less probable. So that's the definition of relevant. So, and excluded under Arkansas Rules of Evidence 403, probative value substantially outweighed by danger of confusion, waste of time, or needless presentation of cumulative evidence. So the trial court's relevance rulings entitled to great deference. These threshold determinations are impossible without a hearing. At this time, the state is left only to speculate as to what the proposed testimony will be, rendering it impossible for the state to make the proper objections under Rules 104A, 401 through 403, and 702 through 705. Okay, so let's see what they're asking for. Wherefore, the state respectfully praises this court grant the motion and schedule a pretrial hearing on expert testimony. Order the defense to provide written summaries of expert opinions prior to the hearing and exclude all irrelevant and inadmissible expert testimony and grant such other and further relief as the court deems just and proper. So, yeah, I mean, like the defense is going to have to turn over whatever, you know, sometimes you don't ask your experts to prepare a report for various reasons. So typically if they do, you have to turn those over. I don't know if that was done here or not. But they're certainly going to have to at least give a summary of what the expert is going to be testifying to. In order to, you can't run in trial by ambush style and not let the state know what your experts are going to be speaking on and what methodology that they used. If you guys watch Karen Reed, you know there was some heavy duty, motions in limine where they were fighting all that kind of shit in terms of the experts that they were trying to get on and which ones they wanted to keep off. So I imagine that there's going to certainly be a dauber for all of the experts that either side is intending on calling a trial. So that'll be something that's going to occur. I feel pretty secure in saying that. Okay, so this is the state's brief in support.
All right, so let me just tell you about this.
Okay.
At least in the Supreme Court of Arkansas case of 1988, it's the only one I'm not seeing anything that goes against this. It says that finally Hart, who was the defendant in that case, argues that the trial judge erred when he refused to give the choice of evil instruction codified in 604. The judge did instruct the jury on self-defense. We held in a prior case that the choice of evil instruction should not be given in a homicide case where self-defense is argued by the defendant. That decision still makes no sense, so this argument must fail. Now, bear in mind, you still have him. I think 604 is still in play as it relates to the forcing the car off the road. So I think that in that sense, if that's what the defense argues, they should be able to raise both, even if this is still the present law in Arkansas, that you don't get a choice of evil instruction if you've gone self-defense. But when you're talking about running that car off the road, that I think is a choice of evil instruction. Am I alone now? Or you're muted, babe?
Sorry about that. I coughed. Okay.
So
I was saying good analysis. Yeah, that makes sense in terms of kind of delineating between the two, because it's really two separate things. Him running him off the road, and then obviously what happens with the ultimate. Yeah.
And the reason that's important is because, again, when you're talking about self-defense, you're talking about who was the initial aggressor, and if he's justified in running the car off the road, they cannot call him the initial aggressor in that situation, even though I understand there's a lot of other factors that could play into that. But I would take that one off the table by providing a justification for it, because if it's legally justified, it's not aggression.
Yeah, I mean, I think ultimately, you know, because that is that first hurdle in terms of him being the initial aggressor. It seems like that's going to have to be litigated prior to, right? I mean, like to me, and I know that one of the briefs comes in and is arguing that, so I won't get into it too much right now. In terms of that initial aggressor thing specifically. All right, so this is the state's brief in support of its previously filed response to the defendant's motion to dismiss felony information on Fifth Amendment grounds.
Did we not? What date is this? Did we not cover this?
No, well, we covered the defendant's file.
I thought find out the date of this, because I thought we might have covered this.
It's 2 days ago.
Okay, sorry, my bad.
It's not that lengthy. I know you were having nightmares of like 20 pages. But
No, the dog keeps scratching at the door.
Okay, so here's the intro. So Spencer's, and again, like this, you'll remember what it was all about. Like the way that the law is currently situated, it's not a winner, but it seems like the law is bad. But so Spencer's motion to dismiss has framed the state's filing of a criminal information in this case as a failure to comply with the Fifth Amendment. This is not so. 28 states currently file criminal charges by information. Yeah, it seems like we did.
Yeah, we did. This is weird. Did they refile it? Because what we did talk about is in those states that they do allow, because Illinois is one of them, you still have to have a preliminary hearing. You either have to have an indictment or a preliminary hearing.
Right. Not just by information.
Not just by information. You can start by information. Sure, start by information. But I also noted that in the defense's motion, they don't mention the fact that it was by information and then there was no preliminary hearing.
Yeah. Yeah. In case you guys don't what they're saying, like in terms of an information, that's basically just some shit that the prosecuting attorney writes up and he goes in front of a judge, says, okay, this is what we got. Judge is like, okay, you're good to go. I'm going to issue the arrest warrant. And then that's it. So with a grand jury, obviously you're going in front of citizens, you're presenting a case, even though it's without the defense or the defendant there, so they could basically do the same shit that they did with an information. But, like in Illinois, file the information, we still have to, we have the right to ask for a preliminary hearing, or we can waive it. It just depends. All right. So 28 states currently file criminal charges by information. They give you the list of them down here. Okay, which I'm not going to read through. See, that's why I remember I said I wasn't going to read through them last time either. So the current controlling state and federal precedent does not require states to use grand juries. Okay, Spencer's reliance on Ramos v. Louisiana is misplaced. Ramos concerned the requirement of, God damn it, Bobby. Where'd I go? I lost it. Hold on. I hit something and I lost it. Okay. Where was I? Oh, so the current controlling state and federal precedent does not require states to use grand juries. So the reliance on Ramos is misplaced. Ramos concerned the requirements of a unanimous verdict in trials by juries under the Sixth Amendment, not the mode of charging under the Fifth. That decision did not overrule Hurtado v. California, an 1884 case, which clearly held that states do not have to indict by grand jury. While Spencer's motion presents scholarly argument that under modern incorporation jurisprudence, the grand jury clause should be recognized as fundamental, those arguments remain outside of the holdings of controlling precedent, which is true. That's what I was saying. The way that the law is currently situated in Arkansas, the state's right on the law here, and Aaron is basically making the argument that the law needs to be changed because it's fucked. So those arguments remain outside of the holdings of controlling precedent. This motion must fail as a matter of current constitutional law. So while Spencer alleges that he is not requesting the court to overrule Hurtado, that is what would be required in order to grant Spencer's motion. It is well settled that the states are not required to charge by indictment, but may charge by information. Hurtado v. California, the Arkansas Supreme Court has addressed this issue many times and has consistently refused to extend the right to grand jury indictment to proceedings in this case or in this state. So while much of the case law has reiterated, you got to mute your phone, dude.
Oh, sorry.
While much of the case law that has reiterated this well-settled matter is prior to the Ramos ruling, the Arkansas Supreme Court has stayed consistent even since I'm assuming that's supposed to be ever since Ramos was decided. The Ramos opinion was issued April 20th of 2020. The defendant in Waller v. State, which was issued in November of 2020, filed a pro se petition for writ of habeas corpus. The defendant had been convicted of first-degree murder, arson, and first-degree battery. Among other arguments, the defendant alleged in his petition and in his argument on appeal that no grand jury indictments were issued for the charges of arson and battery. At that time, the Arkansas Supreme Court reiterated, post Ramos, that the right to a grand jury indictment proceedings does not extend to the state of Arkansas. So they're saying they got to deny it based on the way that the law is currently situated in Arkansas. So there's that, and that will be denied. It's not what the law is right now. Okay, so do we read this thing? More time?
No, but that's just them asking for additional time. I don't think we need to read it.
Yeah, I think we did read some kind of version of this. Okay, so they're asking for more time to file motions because shit's coming in late from the state, blah, 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 blah. Okay. All right, so, all right, now this one was filed again on the 24th, and I think we've seen a version of this also. This might be beefed up version of it. So this is the motion to eliminate to exclude.
And what's the date of that?
The 24th.
What the heck?
To exclude evidence of Spencer's conduct from July of 2024. So the state seeks to introduce evidence concerning Spencer's statements and conduct from July of 2024, shortly after his daughter's disclosed repeated essay by Michael Fossler. The admissibility of this evidence is governed by Arkansas Rules of Evidence 401, 402, 403, and 404B, as well as the due process principles articulated in Andrew v. White, a 2025 case. The July 2024 evidence is irrelevant to any fact of consequence under Arkansas Rules of Evidence 401 and 402. Spencer's emotional reaction to learning that his daughter had been AR'd and his initial interaction with individuals who facilitated Fossler's access to her have no bearing on whether Spencer's use of force 3 months later, after discovering his missing child is in Fossler's truck at night and after Fossler fled with her, was justified. The charged conduct arose from Fossler's actions on October 8th of 2024, not from Spencer's response to the initial disclosure in July. Just absolutely true. So evidence that Spencer, God damn it, Bobby.
It's so weird because we went over this.
I know. She must have beefed it up somehow.
It's a 3-page motion. The other one was longer.
Yeah, I don't
Had
know.
all those details from the police report
Maybe
in it.
like you. She always thinks of other shit she wants to say, so she just keeps filing shit. The charged conduct arose from Foster. Okay, where's the? Am I missing the first? Where the hell's? Oh, in the motion for say. So the defendant. Okay, here you go.
Okay, that's what I was looking for. Why didn't it incorporate something?
Yeah, defendant Aaron Spencer previously filed this motion in limine on October 1st of 2025, pursuant to the court's November 17th, 2025 order requiring that all motions and replies be accompanied by a separate supporting brief. Spencer now resubmits the motion together with an accompanying brief in support. All right.
Okay, so this motion we have read, and
Yes.
it's the brief that's different. So
Correct.
hop to the brief. All right.
Okay.
I thought we read a brief too that had all the details from the police report in it, but read the first footnote. Maybe it says we already filed this brief too.
Okay, so let's see.
Look at that first footnote first.
This is a reply in support of defendant's motion to eliminate to exclude evidence. Let me just make sure it's the right shit. Okay, yeah, this is different. I don't know. Hold on. There's a couple of them. State's brief, defendant's motion to exclude evidence. Okay, so these two are related. All right, amended motion to exclude evidence. Okay, so the state has filed another amended motion in limine. Okay. State's brief in support. Okay.
So we should skip motions, by the way, and just read briefs. If every motion has an accompanying brief, we should just read the briefs.
Okay, let me see if this is the one.
And I think that's what I think we were reading, that second thing that we read, because it had the way it of the states where we were like, this is the exact same. They didn't call it a brief, but they had like introduction, argument, conclusion. So it's like they just took their regular motion and made it a brief.
Mm-hmm. Okay, brief in support of response to state's motion. Okay. Okay,
Have we read the state's motion?
Hold on, babe. Like I've got literally 30 filings that I'm trying to plow through here to see what's what. All right, brief in support of motion for adverse inference of jury instructions, violation of evidence. Yeah, that's a long one too. Okay, let me see. It's hard to say which one it is. Okay, so there's that. Okay, so this is the one. So this is the brief that we're looking for.
That's right.
Okay. All right, so. All right. This was filed right behind it. So I'm going to assume that this is it.
Reply in support of defendant's wait.
There's the footy.
Yeah.
In light of the... Okay, all right. Okay, yeah, I think this is it. Okay.
All right.
All right, so reply in support of defendant's motion in limine to exclude evidence. Okay, so the defendant, Aaron Spencer, by and through his attorneys, files this brief. Okay, so Spencer is charged with second-degree murder, and he has asserted complete justification. Once raised, justification is considered an element of the offense, and the state must disprove it beyond a reasonable doubt. Thus, the determinative question for trial is whether Spencer reasonably believed the Foster was committing or about to commit a felony involving force or violence, and was using or about to use unlawful deadly force, or was imminently endangering the child, and whether Spencer's actions were necessary as an emergency measure to avoid imminent injury. The state's response presents a distorted and incomplete factual account while omitting the chain of events that actually culminated in Fossler's death, namely Fossler's repeated essay of a minor, his release on bond for 43 felony sex offenses, and his ongoing manipulation of the child until the night that he took her from his home, or from her home. Spencer and his wife fully cooperated with law enforcement when the abuse was first discovered. They allowed interviews, provided information, consented to searches, and delivered their daughter for a forensic interview. The state attempts to recast Spencer as someone seeking to, quote, take the law into his own hands, directly conflicts with the extensive record of cooperation. What occurred on October 8th of 2024 occurred only because Spencer discovered his daughter was missing, saw her inside Fossler's truck, and observed Fossler fleeing with her and refusing to surrender her. The state also attempts to rely on statements Spencer made in July of 2024, months before the indictment, as if they shed light on his conduct on October 8th. They do not. Those comments were emotional reactions upon learning that his daughter had been repeatedly AR'd. They were not accompanied by threats or violence, and Spencer immediately calmed and cooperated with the officers. Under 404B, prior statements are admissible only to prove motive, intent, plan, preparation, or absence of mistake. Here, the issue is not whether Spencer intended to kill Fossler or planned to do so. The issue is whether Spencer acted under a reasonable belief of imminent danger. Nothing in the July statements tends to prove or disprove any of the required elements of the state's case or the justification defenses. The state identifies no 404B permissible purpose, and the statements, therefore, are inadmissible. Even if the July statements had marginal relevance, which they do not, they must be excluded under 403. Their probative value is negligible because statements do not concern Fossler's conduct on October 8th. They do not address the threat that he posed that morning, and they do not make Spencer's perception of danger more or less likely. By contrast, the danger of unfair prejudice, confusion of the issues, and misleading the jury is substantial. Allowing jurors to hear months-old emotional reactions risks transforming the trial into a referendum on Spencer's initial anger rather than the circumstances of the assault, the flight, and the threats that occurred on the morning of the incident. Rule 403 requires exclusion when evidence invites emotional judgment or diverts the jury from the central questions at trial, which is precisely what would occur here. I agree. I think that's just where the jury's head would go. Like, they'd start thinking about that. Oh, well, he was super pissed in July. You know what I mean? It's like,
right. No, it's the fair argument, and I think it's the right argument, and I think it should absolutely win the day.
yeah,
But we'll see.
We'll see. So the state's argument also rests on the untenable premise that Spencer somehow had good reason to believe that his daughter was not in danger simply because she may have left her house voluntarily. This misunderstands the dynamic of child SA and grooming and ignores the legal reality that a 14-year-old victim cannot consent to sexual contact with a 67-year-old abuser facing life sentences for crimes against her. Whether she was groomed or forcibly taken is irrelevant. Thank you, Aaron. Especially, or either scenario created a reasonable and imminent threat of harm. No Arkansas statute requires a parent to call 911 instead of acting to stop an abuser fleeing with a minor victim. As Spencer knew his wife, God dang it, I keep clicking and it keeps slipping away. No Arkansas statute requires a parent to call 911 instead of acting to stop an abuser fleeing with a minor victim. And Spencer knew his wife was already on the phone with emergency services. The only relevant inquiry under 5-2607 and 5-2604 is whether Spencer reasonably believed force was necessary to prevent imminent injury. And the state's own probable cause affidavit confirms that he did. Because the statements do not bear on the operative legal questions and would serve only to prejudice and mislead, they're inadmissible under 404B and must be excluded under 403. The jury must decide the case based on the events of October 8th of 2024, Foster's actions, his continued control of a minor, his refusal to release her, his aggressive approach towards Spencer, and the imminent danger those circumstances created. Allowing the state to distract from those facts with months-old emotional comments would improperly taint the jury and distort the issues they are charged with deciding. So it's a strong argument. It's a strong argument. What are you doing?
Agreeing with you.
But you're looking at something. I could tell.
I'm looking at what you have up there.
Oh.
I was shaking my head.
All right. So this again was filed on the 24th. It's lengthier. It's the state's brief in response to the defendant's motion in limine to exclude evidence.
So, and we've read the defense's motion to exclude already, right?
Yes.
Okay.
Okay. So, I mean, this is their July 8th argument, their counter.
Okay.
Okay. Do you want to read one?
Sure.
Do you want you're gonna have to pull it up, or I can scroll for you.
Yeah, you scroll for me.
Okay.
Aaron Spencer is charged with murder in the second degree in the killing of Michael Foster. The chain of events leading to Foster's murder began on July 8th of 2024 when defendant arrived at Leanna Higginbotham's house, an acquaintance of Foster, and told her that he had AR'd his minor daughter and wanted Foster's phone number and address. Spencer told Higginbotham, "Don't call anyone. Don't call the police." Out of concern, Higginbotham spoke with a family member about her interactions with Spencer. Her family member, a mandated reporter, was required to report the R allegations to law enforcement and reported them to Lonoke County Sheriff's Office. The same day, Sergeant John Ingram and Deputy Brian Duke of the Lonoke County Sheriff's Office responded to Spencer's residence to open an investigation about the R allegation concerning his daughter. In parentheticals, it says the interaction was recorded by Sergeant Ingram on his body-worn camera, and the transcription of the relevant portions are included as attachment A. Sergeant Ingram asked Spencer, "Is there any truth to this?" Spencer replied, "I don't know." While attempting to investigate the allegation, Spencer was mainly concerned about the identity of the mandated reporter and his beliefs in the inadequacies of the judicial system. Babe, we've read this, but I'll continue. Sergeant Ingram stated to Spencer, "We still don't live in a country where you can take the law into your own hands." Spencer responded, "Bullshit." See attachment A to the state's previously filed response. Ah, okay. Eventually, Spencer's wife, Heather Spencer, provided information to the deputies regarding the Section A of their daughter. Spencer's daughter was interviewed by the Wade Knox Children Advocacy Center on July 8th, 2024. Cabot Police Department obtained a warrant on July 11th, 2024 for Foster's arrest on one count of R and one count of internet stalking of a child, both Y felonies. Foster was arrested the same day. What's up, buddy? And was arrested the same day and taken to Lonoke County Jail. Foster was seen at his first appearance hearing after arrest. Babe, I gotta deal with the dog. You're muted. You're still muted.
Okay. All right. I'll pull it back up. All right. Let's see. Okay, so while attempting to investigate the allegations, Spencer was mainly concerned about the identity of the mandated reporter and his beliefs in the inadequacies of the judicial system. Sergeant Ingram stated this. Oh wait, she already read that shit. Okay, boop 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 boop. Okay, so on October 8th of 2024 at 1:12 a.m., Heather Spencer called 911 to report their daughter was missing. Heather Spencer said that they found their daughter's bed made up to look like she was asleep, but was not in the bed. Consistent with Spencer's beliefs expressed to law enforcement on July 8th, Spencer proceeded to take the law into his own hands. Spencer later told investigators that he immediately got into his truck to look for Foster, stating he was vigilant for him. See, they keep saying that stupid shit. Spencer left his home traveling westbound on Highway 236. Spencer stated as he was turning onto Highway 31 at the intersection of 236, he saw Foster's white truck pass him, turning onto 236 eastbound back towards Spencer's house with his daughter in the passenger seat. Spencer turned around and began following Foster. He was honking and flashing his lights in an attempt to stop Foster. After following Foster for approximately 6 miles, Spencer's struck Foster's truck containing both Foster and Spencer's daughter. As a result, Foster's truck was rammed into a ditch, striking a wooden entry gate post. After exiting his vehicle, Spencer then began to fire on Foster. Spencer continued to fire a total of 16 times. 15 of the 16 rounds entered Foster. After firing, Spencer pistol whipped Foster in the face. Then, for the first time that night, Spencer called 911 at 1:34 a.m. stating Michael Foster is fucking dead on the side of the road for trying to kidnap my daughter. I had no choice. In fact, Spencer had multiple choices that night. Spencer could have called 911 once he discovered Foster and his daughter. Spencer stated in his interview that he was driving so fast that he could not unlock his phone to call 911. However, a forensic examination of his phone from the minutes leading up to Foster's killing paints a different story. Not only does the examination show that this phone was unlocked, but in use. Spencer had, we've read all this shit. Spencer had a 1-minute, 39-second phone conversation with a family member at 1:16 a.m., received multiple text messages marked read. Who the fuck knows when he read those? And called his wife twice around 1:30 a.m. all around, all before calling 911. Heather had already called 911. Already called him. Spencer had good reason to believe his daughter had snuck out of the house and had not actually been kidnapped that night. I hate this response. This is so disingenuous by the state. Like them trying to frame it in a way that it's not what happened is so fucking slimy. It's so disgusting. And you know what pisses me off more than anything else is the fact that they're re-traumatizing the child. They're making her is part of the problem, which she had nothing to do with it. I don't care if she left involuntarily or voluntarily. Either way, it makes not a bit of difference. He had groomed her. He was like a fucking Svengali. Like the kid was just like whatever. If he texts her and says, I'm out here, and she just walked out, it doesn't matter. It just doesn't matter. Spencer did not want to involve the police when he initially discovered his daughter was essayed, nor did he want them involved when he found Foster with his daughter. Bullshit and bullshit. Spencer's understandable rage did not give him the legal right to kill Foster. Disagree hard. His belief espoused on July 8th to Sergeant Ingram that it was bullshit that we still live in a country where you cannot take the law into your own hands and runs counter to our entire justice system. These people are so full of shit. Who are you gonna convince that some shit that you said 3 months ago, under the shock of finding something horrible out about your child, you're gonna hold that person to what they said 3 months ago under the heat of that moment is utterly repugnant. It's bullshit that are even trying to get it in. It reeks of desperation. It really does. You know, you want to try the case, you want to bring this bullshit case, try it on the facts. Don't try to drag up shit 3 months ago. Again, if he wanted to kill Fossler, he would have killed him the day that he got out on a $5,000 bond. Would have just driven up and put a bullet in that fucking guy's head on that day. It's not what he did. It's not what happened here. Argument. The evidence that the defense wants excluded regarding Spencer's statements that he didn't want police involved in our investigation of his daughter and his implicit comments that he could take the law into his own hands and not be charged with a crime are directly related to his actions on the night of October 8th of 2024. Not only are they relevant statements by a party opponent, the evidence is also clearly admissible under 404B, which allows evidence of other acts that are admissible to prove motive, intent, plan, or knowledge. Bullshit. Oh, God. Evidence is relevant if having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would without the evidence. The probative value is not substantially outweighed by any danger of unfair prejudice, and therefore exclusion under 403 is therefore unwarranted. Spencer's affirmation that one can take the law into one's own hands makes his killing of Foster more probable that it was an extrajudicial act done without any consideration of the law on self-defense or defense of others. Bullshit. What a ridiculous argument. It's a ridiculous argument. Absolutely ridiculous. They're going to try to talk about the heat of this moment, and they're going to try to imply to the jury or directly state to the jury that Aaron was thinking about whatever the fuck he said on July 8th. What, are you kidding me? It's disingenuous. It just is. As much as I don't think that it matters, I'm going to be really pissed if she allows that bullshit in. Truly. Like, I don't think it's going to matter whether they let it in or not. I honestly don't. But the principle of the thing, it's a disingenuous argument. It's a shitty argument. Again, if Aaron had wanted to kill Fossler, he would have put a bullet in his head, vigilante style. He would have put a bullet in his head day one of him walking out of jail, or day two, or day three. or day 4 or day 5, any of the days. Instead, it happened after Foster got his filthy fucking claws back into his daughter. That's when it happened. All right, so the defendant's statements to Sergeant Ingram on July 8th, 2024 are directly relevant under 401 and 402 to the central disputed issue in this second-degree murder case, whether Aaron Spencer killed Michael Foster knowing his conduct was unlawful and without justification. So second-degree murder requires proof that Spencer knowingly caused Foster's death under circumstances manifesting extreme indifference to the value of human life, or that he acted with the purpose of causing serious physical injury or death. His July statement that the prohibition on vigilante justice is bullshit is evidence of that. 3 months later, on October 8th, he consciously believed that he was entitled to act without regard to the law. It is probative of an extrajudicial mindset rather than reasonable belief in the necessity of deadly force. The hell it is. You know what? I wouldn't wish it upon Huggins and his daughter to be snatched out of the night. I'd like to see what he did, what he'd do in that situation. This guy's under the misimpression that people are doing all kinds of thinking in a moment like that, in a panic situation like that. That there's all kinds of thoughts going through your mind. That this is a situation that called for immediate action. It's that simple. If the defense raises justification, the state bears the burden of disproving that defense beyond a reasonable doubt. That comes from Schnarr v. State. Spencer's prior and explicit rejection of the law. When did he priorly reject the law? For 7 minutes when he was pissed off and, he thought what any other parent would think, like, I'm going to go fucking kill this guy. In the moment, 3 months prior, that's a prior and explicit rejection of the rule of law, is it? It makes it more likely that on October 8th, he did not hold a reasonable belief that the use of deadly force was immediately necessary to prevent imminent death or serious physical injury to his daughter. Instead, his statements demonstrate adherence to a personal code under which he viewed a legal system as inadequate and believed that he was entitled to impose lethal punishment to his own or on his own. The evidence will show Spencer had multiple realistic opportunities to call 911 while continuing to follow Fossler and his daughter before ramming Fossler's truck and firing 16 rounds. His phone was unlocked and in active use. His July 8th statements provide the motive for the deliberate choice. He had already announced that his reliance on law enforcement in the courts was, in his view, bullshit. Yet,
he didn't do anything.
7 minutes later, the cops are doing what they're going to do, including leading to the arrest of Fossler. He's then hauled into court. He's charged on 43 counts, and then he fucking bonds out. And then he still doesn't do anything. What is this guy talking about? Like, seriously.
I mean, he needs something. He's doing the best he can.
I guess, man.
Hopefully the court sees through this, because all the points you're making and that the defense makes about it being emotionally charged in just that short period. First of all, what does bullshit mean? Maybe it's bullshit. He's saying bullshit. I wasn't planning on doing that anyway.
I don't know what bullshit meant in the moment.
Right.
Like, I don't give a shit. Like, you know how many times I've said, like, of course not meaning it, but like, I want to kill you. Like when I'm like something fucking like dramatic happens, obviously I'm not meaning that I want to kill somebody, but in that moment in time, you just say shit. Does it like it's got no credence, and it certainly doesn't have any relevance to what happened that night at all. So this directly rebuts any suggestion that his failure to call police was a result of panic, incapacity, or a reasonable belief that law enforcement could not respond in time. Bullshit. Like, what do you like? You're in the middle of chasing some dude with your daughter in his truck, and you're going to be worried about calling 911, trying to see what fucking mile marker you're at. Yeah, like what are they talking about? It's like they're treating things as if everything happens on a piece of paper as opposed to in real life. Like this is real life shit. This isn't on a piece of paper. This isn't about, oh, these are all the things you could have done. Well, fuck you, dude. I'd like to stick you in the same situation and see what you do. Heather had already called 911. They were on notice. They knew what was up. I mean, Aaron found him. I'm sure the cops could find him. They already knew. Were they on the way out? Where were they? I mean, this chase went on for 6 fucking miles. She was on the phone opening the gate for him to leave, telling him, my daughter's gone. Get the fuck out here. Where were they? All right, more probable or less probable than it would be without the evidence. Spencer's declaration that citizens should be able to take the law into their own hands had a clear
I didn't hear that clear. Is this all because the words bullshit?
Yeah.
Okay,
yeah.
That's his clear declaration that citizens should be able to take the law in their own hands.
Yeah. Except he didn't.
Right, but I'm just saying I don't see how that's a clear declaration of anything.
No, I know. I wasn't saying that to you.
I know.
I was saying that to this dude who filed this thing. Had a clear, powerful tendency to make it more probable that A, that he acted with a prohibited mental state on October 8th, and B, that he did not act with the reasonable belief required for justification. In short, the July 8th statements are direct proof of Spencer's rejection of the very legal principles that stand between second-degree murder and a justified homicide. They are therefore relevant and admissible in the state's case in chief. This filing irritates the shit out of me. The probative value of Spencer's statement substantially outweighs any danger of unfair prejudice. It is well settled that most evidence, by its very nature, is prejudicial, and that evidence must be unfairly prejudicial to be excluded. So only evidence that tends to suggest an improper basis, such as raw emotional reaction, is excludable. Duh!
Wow.
Duh! Duh! I mean, like if that wasn't exactly explaining what happened on July 8th, I don't know what does. That exact sentence is exactly what happened on July 8th. So the Arkansas Supreme Court has repeatedly emphasized that evidence offered by the state in a criminal prosecution is likely to be prejudicial to the defendant to some degree. Otherwise, it would not be offered. Accordingly, exclusion under Rule 403 is proper only when the defendant demonstrates that the danger of unfair prejudice substantially outweighs the evidence's probative value. The Supreme Court's application of this principle in Demas and Martinez is instructive, and it strongly supports admission here. In that case, the court upheld the introduction of evidence that the defendant 1 month before a murder possessed a loaded magazine containing the exact type of ammunition later used to kill the victim, even though the possession occurred during an unrelated traffic stop and had no connection to the homicide itself. What?
How the fuck does he think those two things relate? That sounds like identity, that you're identifying somebody. This is the murder weapon found. This guy possessed that murder weapon before. Not he held a gun before, so he might hold a gun now. I don't understand how he thinks that that's instructive at all.
Yeah, was Demas Martinez? Did Demas Martinez happen to find his daughter in the guy's car?
Either way, it sounds like they used it for identification, that he possessed this gun at some point, that it was his fucking gun.
Right, that's how they figured out who the perpetrator was.
That he had access to the gun, whatever. Yeah. This is completely and totally not relatable.
Yeah, it's not on point. No. The court found the evidence probative of access and planning. There you go. Yeah. And held that any incidental prejudice did not substantially outweigh the probative force. So that's pretty distinguishable. The July 8th statements in Spencer's case are extensively more probative than the ammunition magazine. They are not remote or yes, they are. And yes, they are. Or circumstantial. They are Spencer's own rejection of the legal principle he later violated when he executed Michael Fossler, just as the magazine tended to prove the defendant's ability and preparation to commit the murder. And Spencer's explicit contempt for the prohibition on vigilante justice directly proves his motive, intent, and absence of justification on October 8th. You know when that shit would have come in? Had he put Fossler down the day that he walked out after posting bond.
Right.
Then that shit comes in, no problem. Because then this argument holds water.
The best that he could do is this Dean Martinez correlation that is completely and totally like cannot correlate in any way, shape, or form. Has zero bearing on the facts before this court.
Yeah, it's not in any way.
That's the best they could do because they don't have
Right,
shit.
there is nothing out there. So if the evidence from an unrelated traffic stop a month earlier cleared the 403 hurdle, evidence of the defendant's own recorded philosophy of lawlessness. What? Uttered in the same into his philosophy of law. 7 minutes later, the cops are doing their shit. They're like, you know what? Cooler heads have prevailed. Do what you're gonna do. And they did.
I don't care if you planned and wanted to murder a bad guy, and then that bad guy starts to pose a imminent risk to you, you can kill them. Even if at one point in time you wanted to kill them when they didn't pose a risk. It's still justified.
Right.
It's like I don't get it.
Right. One has
Either
nothing to do
justified
with
or
the
it's
other.
not. Whether you
Right.
wanted the guy dead is irrelevant.
Right. And I'm sure Aaron did. Deep down.
I think I gave the analogy before, like somebody torments your entire family, kills a family member, you want them dead, you try to hunt them out, you want to kill them, and then 2 months later they break back into your house, they take your kids, they've got a knife to your kid's throat, and you kill them. I mean, obviously I'm being way more, but I'm just saying the fact that you wanted that person dead before does not change the fact that you have every right to kill them right then and there.
Right, 100%. So, evidence of the defendant's own recorded philosophy of lawlessness uttered in the same investigation that gave rise to the homicide easily satisfies the balancing test. This guy lives in a fucking dream world. The state seeks admission only to prove Spencer's state of mind and to rebut justification. Therefore, no improper basis is invoked. The danger of unfair prejudice is negligible. The probative value is overwhelming. Rule 403 does not require exclusion. So Spencer's statements are independently admissible under Arkansas Rule of Evidence 404B.
Bullshit.
Even if the statements were considered other acts, wrongs, or crimes evidence, which they are not, because expressing a belief, as Spencer did, is not itself criminal conduct. They are squarely admissible under the well-established 404B exception. So 404B provides that evidence of other crimes, wrongs, or acts is not admissible to prove the character of a person in order to show that he acted in conformity therewith. It may, however, be admissible for other purposes such as motive, proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident.
Okay, so I just want to say, and I've noted this like 150 fucking times, that this is not 404B evidence because it is not other wrongs, acts, and he just said they were not. It wasn't other crimes, wrong, bad acts, or anything. So it should be allowed in. But that rule specifically deals with when you can bring in bad acts, crimes. So I don't understand what he's doing here either.
They're trying to bring in thought crimes. Thought crime. I thought about it. Thought crime. Going to prison on a thought crime. Good old 1984 shit. So here, Spencer's recorded assertion that it is bullshit that citizens cannot take the law into their own hands is independent evidence of motive, intent, plan, and knowledge, and absence of justification. It shows a pre-existing vigilante ideology that drove his actions, an advanced awareness that his course of conduct was illegal and that he proceeded anyways. And also disproves that he did not act under a reasonable belief that deadly force was necessary, but instead pursuant to his previously announced contempt for I cannot wait for this trial.
Oh God, I can't wait for this hearing. I just what he is saying here is precisely what you can't use the evidence for. You can't say at some point in time he said that citizens should be allowed to take the law in their own hands. So you should believe here citizens are allowed to take the law in their own hands. That's the exact reason it can't be used.
Conclusion. So Defendant's July 8th statement to Sergeant Ingram are relevant under 401 because they make it substantially more probable that Spencer killed Foster with the culpable mental state required for second-degree murder and without any legal justification. Their probative value in revealing his mindset, motive, and intent far outweighs any danger of unfair prejudice under 403. Independently, the statements are admissible under 404B. Exception is direct proof of motive, intent, plan, or knowledge, or absence of mistake or justification. Because the statement satisfy rules 401, 403, and 404B on every level, the defendant's motion to eliminate must be denied. Okay, Chuck.
This judge isn't a total asshole.
Okay, Chuck.
When's the hearing?
We don't know yet.
There's no hearing set for motions in limine?
I don't know. Like, there's a court order in here somewhere.
All right. Now, I want to be sure we don't read one we've already read. So let's...
Okay, so this is... All right, so this is them trying to exclude those witnesses. So I think it feels like we just read this one. So this is with the failure to disclose what those witnesses were going to testify to. So I think we've already read that one. Or
so exit off so you don't ever...
No, I mean, like, I think they just, like, filed something very similar to it. All right, so this is state's brief in support of its... in support of its response to defendant's notice to raise justification as defense.
So that's what we just went over with how 404B you can't, with 604 you can't also get if you're using 607.
Right. So, okay, the defense has provided notice to the state and this court that it intends to raise justification under 604, 606, and 607. So Arkansas Code 604, the choice of evils, provides an emergency or imminency defense that states that this is what you already read, right?
Yep.
Do you want to read it? Okay.
Well, you go ahead.
Okay, so conduct that would otherwise constitute an offense is justifiable when the conduct is necessary as an emergency measure to avoid an imminent public or private injury, and according to ordinary standards of reasonableness, the desirability and urgency of avoiding the imminent public or private injury outweigh the injury sought to be prevented by the law prescribing the conduct. So justification under this section shall not rest upon consideration pertaining to the morality or advisability of the statute defining the offense charged. If the actor is reckless or negligent in bringing about the situation, requiring a choice of evils, or in appraising the necessity for his or her conduct, the justification afforded by this section is unavailable in a prosecution for any offense for which recklessness or negligence, as the case may be, suffices to establish a culpable mental state. So 606 provides a justification defense which allows for the defense of others and states, A1, that a person is justified in using physical force upon another person to defend himself or herself or a third person from what the person reasonably believes to be the use of imminent or imminent use of unlawful physical force by that other person, and the person may use a degree of physical force that he or she reasonably believes to be necessary. 2, however, the person may not use deadly force except as in provided by 5-2607. A person is not justified in using physical force upon a person if, 1, with purpose to cause physical injury or death to the other person, the person provokes the use of unlawful physical force by the other person, or 2A, the person is the initial aggressor. So, however, the initial aggressor's use of physical force upon another person is justifiable if, 1, or I, the initial aggressor in good faith withdraws from the encounter and effectively communicates to the other person his or her purpose to withdraw from the encounter, or II, the other person continues to threaten or continue the use of unlawful physical force, or physical force involved is the product of combat by agreement, not authorized by law. C, a person who uses or threatens to use physical force is otherwise permitted under this subchapter does not have a duty to retreat before using or threatening to use physical force if the person is lawfully present in the location 2, not engaged in criminal activity that gives rise to the need to use physical force, and 3, not engage in the activity in furtherance of a criminal gang, organization, or enterprise. So 502 or 5-2-607 on the law of self-defense states, person is justified in using deadly force upon another person if the person reasonably believes that the other person is committing or about to commit a felony involving physical force or violence, using or about to use unlawful deadly physical force, or 3, imminently endangering the person's life or imminently about to victimize the person from the continuation of a pattern of domestic abuse. B, a person is not required to retreat using deadly physical force if the person is lawfully present at a location where deadly physical force is used, has a reasonable belief that the person against who the deadly physical force is used is imminently threatening to cause death or serious physical injury to the person or another person, except as provided under 606B2B, is not the initial aggressor and has not provoked the person against whom the deadly force is used. So, like, there is no argument here that can ever withstand any kind of scrutiny wherein Aaron Spencer is the initial aggressor.
No.
Like, if they try to make the argument that him running him off the road makes him
justified.
Totally justified.
It has to be unlawful force. It has to be unlawful force.
Right.
So that's how 606 still stays in, because that's unlawful force that's not deadly, and so is 604. The act of running his car off the road.
Yeah. All right. 4 is not committing a felony offense of possession of a firearm by certain persons with the firearm used to employ deadly physical force unless the person is in or at the person's dwelling or in the curtilage surrounding the person's dwelling, is not engaged in criminal activity. Okay, so 5 and 6.
So, and again, 5 says criminal activity that gives rise to the use of force. Again, he's justified in running that car off the road. He's not involved in criminal activity.
Right. 100%.
So Hart is the case that I read earlier that still says you cannot use 604 if you're also using 607.
Okay, but so it says the instruction should not be given. But based upon this case law, if the defense raises a self-defense or defense of others defense, it may not also raise the choice of evils. So, I mean, he doesn't really make an argument.
Right. But I mean, I think that's fair. If you can't get an instruction on it, that means you can't raise both, because that's how you raise it, or that's how the raising of it becomes something the jury can consider, is them getting an instruction on it.
Yeah. I'd be curious to know why Aaron decided to stick that one in. I'm talking about Casanelli, like what her thinking was in terms of feeling like she needed to have that added.
But like we said, it could deal with taking the car off the road and not.
Yeah, right. Which was the only place that I think that it applies. But I mean, in terms of like figuring out that first hurdle, that like who the initial aggressor was, I mean, I don't know how it's going to play out. I don't know how
well, that would become a question of fact for the jury to decide.
Right. 100%. But it seems like if that's, but it conflicts with that statute.
Well, the jury will be instructed that you can't if you find him to be the initial aggressor, this defense does not apply. But it's still for them to decide. It's a question of fact.
No, I know that. What I'm talking about the evils one, like in terms of like determining, like because the only point in time that they could be ever trying to say that Aaron was the initial aggressor is when he runs the truck off the road. That's the only place where that evaluation takes place. It can't be any other place.
Right. I don't think it's an issue.
Yeah, I don't think it's an issue either. All right, so okay, this is a long one. I need a drink. All right, so this is the brief accompanying the reply in support of the defendant's motion to eliminate to exclude the evidence. Okay, so we know that he's charged with second degree.
Wait, we've read this one, babe. This is the one. Scroll down and see if it cites the police report. Scroll.
Okay.
She had it in block, I think. So you'll see it right off if it's in there. Wait, maybe. Yeah. Okay.
What?
See that footnote? Go down and look at that footnote.
Yeah, I see.
We read that. It seems the state is sensitive about the language described to 60. Like we read this. She's just refiling all of this stuff because the judge wanted the brief filed with the.
So you're 100%. We read this.
Yeah. Keep going to where.
Oh yeah, I remember this.
They mentioned the dog.
Yeah.
Spencer and his wife were concerned the person lied to them. So we covered this.
Oh yeah,
And there's the block. There's the affidavit. Okay, but what we didn't do is read the affidavit. So let's do that. It's
Okay.
attached, I think.
Oh yeah, you're right. Allie's like, we didn't read the affidavit. I was like, oh, I thought it was over. Okay.
Oh, is it not there?
No.
Well, it was on the other one. Let me see. Hold on. I got Tracy's emails up. This might be it. Oh no. Let me see.
All right, I want to run and get a drink real quick.
Okay. I thought maybe the affidavit wasn't attached. I thought the affidavit was attached. I don't know if Tracy's out there. Okay, maybe it wasn't attached. Okay. All right. Yeah, I don't think it was attached. Just whoops. Damn it. Motion for adverse.
All right, sorry about that. Were you able to confirm?
Yeah, I don't think maybe I was wrong and it wasn't attached.
No, but is it the exact same thing? 16
Exact
pages?
same thing.
Exact same thing.
Exact same motion. Yes.
Exact. Okay. All right.
Ay.
All right. So
what I think we should do is I'm just gonna, because
we're close.
there's a brief in support of the adverse inference. Let's go to that. And that's a long one.
It is?
Yeah.
Okay.
I have it up if you want me to just do it, or
yeah, you can do it. Like, I've been reading a long time.
all right. Whoops. All right. All right. Brief in support of motion for adverse inference jury instruction and hearing on spoliation or destruction of evidence. The defendant, Aaron Spencer, by and through his attorney, requests an adverse inference instruction to remedy spoliation and destruction of evidence resulting from Lonoke County Sheriff's Office loss of the memory card containing the dashboard camera recordings from Michael Foster's vehicle. What? What? He had his own dashboard camera? Oh, wait. From Michael Foster's vehicle? What? All right. Spencer also seeks an evidentiary hearing to show this loss violated his constitutional due process rights. Relevant facts: Aaron Spencer intends to argue that trial that he killed 67-year-old Michael Foster while defending his then 14-year-old daughter, whom Foster had picked up from her home in the middle of the night. Mr. Spencer's daughter was the key witness against Foster in a pending case involving 43 felony counts, all stemming from Foster's sexual exploitation of her. Sorry, now I've got to mute. Including internet stalking, SA, and child pornography. Those offenses carried a potential life sentence and would be capital crimes if charged today. And yet Foster was free on bail on the night of October 8th, 2024, when Spencer discovered his daughter's bed was empty. The Spencers called the police and then went to find his daughter. And then he went to find his daughter. As Mr. Spencer drove around looking for his child, he crossed paths with Foster's truck and saw her in the passenger seat with Mr. Spencer behind him. Foster fled with Mr. Spencer's daughter. Mr. Spencer feared not only the repeated assaults on his child, but also that Foster would eliminate the only witness threatening to secure his life sentence. To prevent further harm to his child, Mr. Spencer forced Foster's truck to a stop. Foster exited the vehicle and continued to pose an imminent threat to Mr. Spencer and his daughter. Mr. Spencer killed Foster to protect himself and his child. Mr. Spencer later learned that Foster's vehicle contained a dash camera. The device would have captured the events of that evening, including the routes Foster traveled before and after taking the minor into his custody, as well as his encounter with Mr. Spencer during and after the pursuit. Wow. That recording constituted critical evidence for the defense. What? In July of 2025, defense was informed by Chief Deputy Prosecutor John Huggins that the memory card containing the footage had been lost. Wow. After being taken into evidence by the Lonoke County Sheriff and cannot be produced. The Lonoke County Sheriff's Office did not secure the camera in a protective storage container, log the camera and its memory card as separate evidence items, or follow other standard procedures for preservation of physical evidence. Detective McCain allegedly removed the memory card from the camera, viewed the footage.
Oh my God.
And then sent both the camera and the card to the Attorney General's office. Only the camera arrived. The memory card has since come up missing. Are you fucking trying to tell me we are to believe that he sent the memory card and the camera separate? Two different shipments here?
Wow.
I'm going to mail you the camera and then I'm going to mail you the memory card. Wow. So defense counsel was further told that the sheriff's office is, quote, pretty sure the memory card got kicked out of the camera in transit to the AG's office. No one knows for certain, though. It must be an email, which is why somebody wrote THO. Wow.
Holy shit.
What the fuck is going on in Arkansas? What the fuck kind of bullshit is this? Why in the hell? It makes no sense to me. Why in the hell, if they had this evidence, wouldn't they just drop the fucking charges? I don't get it. I don't get what's going on. I don't get what's going on. It makes no sense.
Crazy.
Well, he should absolutely get an adverse inference instruction. Mr. Spencer therefore seeks an adverse inference instruction and an evidentiary hearing under California v. Trombetta and its progeny. First of all, why wouldn't they have saved it, uploaded, stored it, made a copy, sent a that is not the way things are done. You don't take the entire thing with no backup, no nothing, and send it off. Like, what the fuck is going on? Wow.
That's insane.
All right. Argument. Adverse inference instruction. Under Arkansas law, spoliation is defined as the intentional destruction or loss of evidence. So that's where we're going to have the first issue, right? They're going to argue that we can't prove, that the defense can't prove it's intentional. And when it is established, the fact finder may draw an inference that the evidence was destroyed, that the evidence destroyed was unfavorable to the party responsible for its spoliation. And they cite this Goff v. Harold Ives 2000 case. The Arkansas Supreme Court approved a remedial jury instruction for spoliation in Bun Builders, Inc. That's a 2011 case. Arkansas, what's the M instruction? Arkansas Model Instruction 106 correctly and adequately sets forth the law with respect to spoliation of evidence and the adverse inference drawn from it. This instruction reads as follows. If you find the party intentionally destroyed or lost or suppressed, describe the item with knowledge that its contents may be material to a pending or potential claim, you may draw an inference that the contents of the document or the item. What are you listening to? The Gacy buried?
No, I wasn't listening to it.
Would be unfavorable to that party's claim or defense. When I use the term material, I mean evidence that could be a substantial factor in evaluating the merits of a claim or defense in this case. All right, so maybe they're not going to get an instruction on that ground. Arkansas courts have deferred to this instruction in evaluating the applicability of a spoliation instruction in a criminal case. Federal courts have held likewise. And they cite a couple cases talking about spoliation, adopting the standard of spoliation. The Ninth Circuit has developed a model criminal jury instruction 4.19 to specifically address the government intentionally destroying or preserving the evidence.
Is the government ever going to admit that they've intentionally destroyed something? It's fucking counterintuitive. They're never going to be like, yeah, we destroyed it. It killed our case. Like, they're never going to admit that. Like, well, I think that it has to be proven. There has to be a burden on the state to prove that they didn't intentionally destroy it.
Yeah, I mean, how does it get okay? So it gets separated from the camera.
They could just say that shit all the time. Oh, yeah, I don't know. Got lost in the mail. It must have popped out of the fucking camera. I don't know. I don't know what happened to it. Bullshit. It's ridiculous.
All right.
I mean, what did this goofball see? Like, what did the guy who viewed the video see? What, like, I'm dying to know.
Right. All right. So here, an adverse jury instruction is necessary because the government lost a memory card containing video footage of the shooting and the events immediately preceding it, despite knowing that the footage was material to Mr. Spencer's defense. Discovery shows that the Lonoke County Sheriff's Office failed to follow its own procedures for documenting and preserving evidence. So there's something that I'm sure they'll get into as being something that you can take into consideration and determine it was intentional when they failed to follow procedures. Also, where is the police report of what he saw? Where is the police report that I viewed this? This is what was contained on it. The dashboard camera was not placed in a protective container, such as an evidence bag, that would have prevented the memory card from being knocked out during transport. If it's knocked out during transport, isn't it still in the damn bag? Isn't it still in the envelope?
Theoretically.
The memory card does not appear to have been logged into evidence at any point, even though LCSO deputy has stated he removed it from the camera and viewed the footage. Footnote 1 states, although the LCSO, that's the
Where did he do that? Where did he view it?
I don't know, did not inventory the contents of Foster's truck until July 8th, 2025, more than 8 months after his death. Its investigators removed the dashboard camera far earlier, shortly after the October 2024 shooting. Because of these failures by the Lonoke County Sheriff's Office, material evidence no longer exists. The state therefore breached its duty to maintain evidence necessary to ensure basic fairness in the litigation process. True. The state's suggestion that the device contained no material footage does not withstand scrutiny. To begin, Detective McCain's assertion, there you go, that all video files on the card were recorded after the incident and just showed blue lights in the background conflict with the camera's capabilities. Foster's dashboard camera was equipped with 2 lenses, a wide-angle front camera and a rotatable interior cabin camera, capable of recording both the road and the vehicle's interior and behind the truck. In addition to blue lights in the background of the exterior recording, there also would have been footage from the opposite direction, including the interior. The interior footage would have captured the danger Spencer's child faced that night and the trauma she experienced. Wow. Similarly, Detective McCain's belief that the dashboard cam records on a continuous loop, so it only shows what was there until it was unplugged, reflects a misunderstanding of how dash cameras function. Turning off the vehicle ordinarily stops the recording. It does not overwrite existing files. There also should have been no need for any file to be overwritten. The camera is marked HD 1080p, and a memory card of the type commonly used in such devices typically stores approximately 16 to 20 hours of footage at that resolution. Overwriting the relevant video would have required the truck to idle for several hours with the camera actively recording. In addition, most dashboard cameras contain a gravity sensor that detects sudden impacts or collisions, such as those that occurred during the events of October 8th, 2024. When triggered, the sensor locks and the file being recorded, preventing it from being deleted by loop recording.
Wow.
For Detective McCain's statements, as relayed by Mr. Huggins in his email, to be true, the exterior camera and the gravity sensor both would have needed to fail. The memory card would have needed to be unusually small, and the truck would have needed to be idle for hours until the camera recorded enough footage to overwrite all relevant files. Such a convergence of circumstances is unlikely. I would say implausible.
Yeah.
Finally, there is no need to remove the memory card at all because the camera had a built-in screen that allowed the video to be viewed directly on the device. Footnote 2. Removing the memory card without adequate safeguards may itself constitute tampering with physical evidence, a felony under Arkansas law. A person commits that offense if he or she alters, destroys, suppresses, removes, or conceals any record, document, or thing with the purpose of impairing its verity, legibility, or availability in any official proceeding or investigation. Returning to the body. In sum, the Lonoke County Sheriff's Office failure to secure, document, or preserve the memory card and needlessly removing it from the camera, resulting in the loss of material evidence. This reckless mishandling amounts to losing or destroying this evidence intentionally. The lost video footage would have shown how Foster persuaded the child to leave the safety of her home, which is irrelevant, but Foster's behavior, manipulation, deception, and or threats, and the moments leading to and immediately preceding his death. This information is manifestly relevant to determine whether Spencer's defense was justified. Although some portions of the footage may be partially reconstructed through witness testimony, medical records, and crime scene analysis, these sources are not a complete and fair substitute. The video would have provided a level of objective information that cannot be fully replicated through subjective recollection or written documentation. Simply put, Spencer has been obstructed from fully presenting his defense. To truly right the wrong the state has inflicted, Spencer is entitled to a curative instruction read to the jury at the conclusion of the evidence. If you find that the state intentionally lost footage from Foster's dash cam with the knowledge that it may be material in a potential case against Spencer, you may draw the inference that the dash cam footage would have been favorable to Spencer and unfavorable to state. When I use the term material, I mean evidence that could be a substantial factor in evaluating the merit of a claim or defense in this case. Hey, babe, can you pull the same thing up and read section 2?
Yeah.
This instruction preserves the state's right to produce other relevant evidence and does not preclude Spencer or his daughter from testifying as to their own actions or actions they observed, with the state investigative witnesses being subject to cross-examination regarding the loss of the dash cam footage.
You sound warbly.
What do you mean?
Like your voice sounded like it was quivering or something.
Yeah, I need a drink.
Okay.
I need to up my I never actually took any additional pain medicine when I went up and changed. Like, nights are rough for me.
I'm pulling it up. Okay. All right. So this is argument 2. Okay. For the reasons that follow, destruction of evidence warrants a hearing under Brady v. Maryland and California v. Trombetta. For the reasons that follow, Spencer asks for an evidentiary hearing to establish grounds for dismissal under California v. Trombetta and its progeny. Specifically, Spencer argues that charges against him should be dismissed as a result of the state's destruction of evidence in violation of the Due Process Clause of the 5th and 14th Amendments of the United States Constitution and Article 2, Section 8 of the Arkansas Constitution, and the principles set forth in Brady v. Maryland and California v. Trombetta, further developed by Arizona v. Youngblood. The interest of the government in any criminal prosecution, quote, is not that it shall win a case, but that justice shall be done. In addition, criminal prosecutions must comport with prevailing notions of fundamental fairness, requiring that criminal defendants be afforded a meaningful opportunity to present a complete defense. And that's as such, the U.S. Supreme Court developed, quote, what might loosely be called the area of constitutionally guaranteed access to evidence. And then accordingly, the court required that prosecution disclose all evidence favorable to the accused that is material either to guilt or punishment. And then finally, Brady defines exculpatory evidence as evidence favorable to the accused and material either to guilt or punishment. The court has held that the suppression by the prosecution of evidence favorable to an accused upon request violates due process where the evidence is material either to the guilt or the punishment, irrespective of the good faith or bad faith of the state. Further, the duty to disclose such evidence is applicable even though there has been no request by the accused. And encompasses evidence known only to the police. To comply with Brady, therefore, an individual prosecutor has a duty to learn of any favorable evidence known to the others acting on the government's behalf, in this case, including the police. Ultimately, this group of constitutional privileges delivers exculpatory evidence into the hands of the accused, thereby protecting the innocent from erroneous conviction and ensuring the integrity of our criminal justice system. When, as here, the state destroys or loses material exculpatory evidence that might be expected to play a significant role in the suspect's defense, it violates the Due Process Clause of the 5th and 14th Amendments and Article 2 of Section 8 of the Arkansas Constitution. In Trombetta, the court addressed the prosecution's duty to preserve evidence on behalf of criminal defendants. Quote, under the two-pronged Trombetta test, the government violates a defendant's right to due process when, one, it destroys evidence whose exculpatory significance is apparent before destruction, and two, the defendant remains unable to obtain comparable evidence by other reasonably available means. Okay, the Supreme Court and the circuit courts have held that no showing of bad faith is necessary in this instance. On the other hand, the court in Arizona v. Youngblood developed the principles of Trombetta to clarify that when the evidence is only potentially useful, meaning the exculpatory evidence of the exculpatory value of the evidence is unknown, the defendant required to show that the government acted in bad faith in destroying the evidence. So the court in Illinois v. Fisher reiterated the holding in Youngblood that the necessity of showing bad faith depends on, quote, the distinction between material exculpatory evidence and potentially useful evidence. The Eighth Circuit followed suit. A due process violation arises from destruction of evidence when the evidence possesses an exculpatory value that was apparent before the evidence was destroyed and is of such nature that the defendant would be unable to obtain comparable evidence by other reasonably available means. A higher standard of proof applies, however, when the evidence is only potentially useful to the defendant. Unless a criminal defendant can show bad faith on the part of the police, failure to preserve potentially useful evidence does not constitute a denial of due process of the law. So the presence or absence of bad faith by the police for purposes of the due process claim must necessarily turn on the police's knowledge of the exculpatory value of the evidence at the time it was lost or destroyed. For example, in Ohio v. Dernwald, the court found bad faith when an officer watched but then failed to preserve the video traffic stop and DUI arrest by accidentally taping over it. The court reasoned that the tape may have supported the appellant's version of his actions during the stop and therefore is potentially useful. Accordingly, to show the defendant's due process rights were violated, he must demonstrate that the trooper's actions amounted to bad faith. Given the obvious evidentiary value of the recording, the court found assertions that overwriting the tape was a mere accident was not credible. Okay, since that it was likely the defendant may ask for the videotape and it has obvious evidentiary value and importance to substantiate a trooper's version of the events leading up to an arrest, this court finds it incredible that such accidental erasures continue to occur. Once made, the videotape must be preserved, just as any other evidence regarding an alleged crime or arrest would have been preserved. The court found that such cavalier attitude towards the preservation of DUI videotape evidence rises to the level of bad faith, where erasure was not product of machine malfunction, but instead due to complete and utter failure to safeguard evidence relevant to a crime and arrest. Here, too, the destruction of the evidence appears to stem from a complete failure by the Lonoke County Sheriff's Office to safeguard material evidence related to a death investigation and an accompanying arrest. The video footage of the moments leading up to the shooting had obvious evidentiary value, and it was highly likely the defendant charged with second-degree murder would ask for the recording of the encounter to substantiate his defense. And yet, the Lonoke County Sheriff's Office, after reviewing the video and determining its exculpatory value, failed to even take the minimal steps necessary to preserve it, such as securing the camera and its memory card in an evidence bag. The officer then lost track of the memory card entirely. Such cavalier attitude towards the preservation of video evidence in a homicide case supports a finding of bad faith. Sure the fuck does. Because you could bet your ass. Had that video shown Aaron shooting Fossler through the window of the truck, that they wouldn't have lost it. You could bet your ass they wouldn't have lost it. For the reasons Spencer requests an evidentiary hearing to explore the loss or the destruction of the memory card by the Lonoke County Sheriff's Office and its failure to preserve this evidence, Spencer expects to show that this reckless mishandling warrants relief, including potential dismissal of the charges under California v. Trombetta and its progeny. So, conclusion, Mr. Spencer respectfully asks this court to grant his motion for an adverse inference, jury instruction on spoliation. Mr. Spencer also asks the court hold a hearing to establish the memory card's exculpatory value and to show the loss of this evidence was due to utter failure of the Lonoke County Sheriff's Office to follow its own evidence preservation procedures. This failure warrants relief, including potential dismissal of the charges against Mr. Spencer. All right, so what do we got here? Exhibit A. All right, so we got an email attached here. It's from Huggins, the prosecutor, to Aaron and Michael. It's like, so this is July 3rd, 2025. It's like, hey, Aaron, I wanted to let you know about a dash cam that was apparently in Fossler's truck that was taken into evidence by Lonoke County Sheriff's Office. After the incident, Detective McCain took the micro SD card out and reviewed the video files on it, but all the files showed to be after the incident, and it just showed blue lights in the background and no other inculpatory evidence. He believes the dashboard cam records on a continuous loop, so it only shows what was on there until it was unplugged. Detective McCain sent the dash cam unit along with the SD card to the AG's office for Amber Calmer to do a forensic exam of it. It has since come up missing. Wow. They have been combing their desks in CID for months trying to find it without any luck. At this point, I'm not sure it will be found, but I will let you know when that happens, when and if that happens. Wow. So this is from the cop, from McLean to Huggins. No, pretty sure it got knocked out of the camera in transit to the AG's office. No one knows for certain, though. Wow. From Huggins to McCain, July 3rd. So this one was sent on July 3rd at 1:24 p.m. and 1:23 p.m. Huggins had said, oh, yeah, that's right. Sorry, it's been a bit. Any luck finding the SD card? What the fuck? And then McCain back to Huggins at 11:17 a.m. on July 3rd. In regard to the dash cam, I talked to Amber and she confirmed that the camera had no internal storage. Jesus. What the fuck? What the fuck? Are you serious? Like, what? Oh my God. That is insane to me. That is absolutely insane. Like, talking about cavalier attitude. Oh, I don't know. Like, what I'm asking is, like, what did he watch? He took the card out and either had an adapter or whatever he used to watch it on his computer. Like, why wouldn't they have downloaded the video there when you're watching it? Why wouldn't you save it? Like, first and foremost, he takes it out of the camera. He views it on some device. Like, I want to see all the fucking metadata. I want to see what he watched it on. They're gonna have to prove this shit up. That is disgusting. Ugh. God, the lengths that they're going to try to convict Aaron Spencer is just beyond. Like, I don't get it. Fucking kidding me? All right. That's outrageous. All right, so this is a shorty. So let me see. Well, let me make sure. Okay. Okay, so no, negative. Alice is trying to get me to rap. I'm finishing all these things. That was the longest one by far. Okay, so this is a notice of withdrawal of both the motion in limine and the supplemental motion in limine. This is relating to the glass smoking device. As we know, it says here that the state had produced an interview and written statements from a detainee who reported that he left the device in the patrol vehicle several weeks before October 8th. In light of this information, there's no remaining issue. As we know, the state said, we agree, can't come in. All right, so we don't have to worry about that one. All right. This is a little court order that was filed by the judge, order denying motion to file under seal. So the defense had filed a motion to file under seal. Based upon the reasoning of defense counsel, the court will allow the parties to use the minor's initials to refer to any all minors. However, the court at this time will not at this time have any court documents filed under seal. So they wanted to file something under seal that had their daughter's name and or initials attached. Okay.
Hey, you know, I wanted to say, shit, hold on a sec.
That's
well,
good.
I can say it while I just can't hear you, but what if they didn't? What if that guy didn't admit that he left that shit there? You think the state would be agreeing to shit?
Wait, what?
If that guy had to admit it was his crack pipe.
I mean, I don't know. Like I think that I think
I'm
it.
out.
All right, yeah, you be out. Like it sounds like you're in agony.
Okay, I'm back.
Oh, I thought you were out.
I was gonna be out, but I see the problem is I'm trying not to take the pain medicine now, which is just taking my 2 Advil, 2 Aleve, and 2 Tylenol at the same time. I mean, that's the pain medicine.
Like I'm close. Like I think
Until later.
I think
so
there's
that I
only
can
a couple
sleep.
more things to read anyway. Like you can dip.
Yeah, but then I hear something interesting and I don't feel like typing it and I want to chime in.
All right. Okay, so this is
All right, now I'm out.
Keep going. Keep going. All
Bye,
right. So
guys.
this is the brief in support of love you. Bye.
Bye.
Brief in support of response to the state's motion in limine to exclude evidence. So state moves to exclude all defense experts. Okay. And one, we've got although the state's motion refers to 3 disclosed defense experts, the defense now has provided notice of 4. There's a new one. Okay. The motion offers no legal or factual basis. Oh, it sounds like Nick McClelland and Hank. They don't really give any kind of legal argument or factual basis for exclusion. They just say they want it to happen. So these the motions offer no legal or factual basis for exclusion, and instead asserts only that the subject matter of the expertise reflected in the expert's CVs appears irrelevant. This assertion is unfounded. Each of the defense's potential experts has expertise directly relevant to the unusual and complex circumstances underlying the charge and the defenses in this case. To ensure timely notice, the defense provided the state's experts CVs at the same time the defense is still receiving discovery from the state that must be provided to the experts, which means the experts are still reviewing materials and formulating their opinions. The state has produced a significant volume of discovery within the past 2 weeks. Due to the volume and nature of the data, the discovery required manual copying of hard drives at each step of transmission. First from the state to the defense counsel, and then from the defense counsel to the experts, which took several days to complete. Much of this material is directly relevant to the experts' analysis and was sent to them this week. This morning, the defense received additional pertinent information from the state that must now be copied and mailed. A substantial part of the anticipated expert testimony will be in consideration of and in response to the state's presentation at trial, if necessary to rebut evidence introduced by the state. Until the state's witnesses testify and the state conducts its cross-examination of defense witnesses, it's impossible to know which issues will require expert clarification and rebuttal. For example, the defense has identified a crime scene expert. If the state's evidence does not raise issues concerning the crime scene investigation or analysis, this testimony may not be needed. So the information technology expert, the defense intends on calling an information technology expert to address electronic digital evidence collection and any relevant data found in those collections. He must also testify to issues regarding Fossler's dash cam and cell phone or cell tower data. Based on the state's filings, the defense presumes that the state will call a similar witness. Testimony addressing the reliability, completeness, and significance of electronic data is plainly relevant and will assist the trier of fact. The child essay and exploitation expert. The defense will call an expert in child SA and exploitation. She will testify regarding the characteristics and behaviors of child victims and offenders, the nature of the SA investigations, and the dynamics of abusive relationships like the one Fossler created with MS. This expert will educate the jury generally about the SA and exploitation of minors. She will explain the purpose, effect, dynamics, and progression of Fossler's abuse of the minor both before and after his arrest. This testimony is essential given the state's suggestions in prior pleadings that the child victim may have been complicit or that Spencer lacked reason to believe that she had been kidnapped. Exactly what I was saying during that live when Allie and I were going toe to toe. Or that Spencer lacked a reason to believe that she had been kidnapped or otherwise in danger on the night in question. The grooming, manipulation, and deception employed by Fossler and other pedophiles to control and manipulate their victims are central to understanding the circumstances Spencer confronted on October 8th of 2024, the crime Spencer reasonably believed Fossler was committing. So crime scene expert, the defense may call a crime scene expert to explain accepted practices in crime scene investigation and analysis to compare those principles with the investigation conducted in this case and to address the evidence located at the crime scene in this case. His testimony will be informed by the state's investigative materials, standard procedures, and the trial testimony of the state's investigators. I wonder what that guy will think about losing the little SD card from the camera, the dash cam. I wonder if he'll think that's good police work. Is that good police work? In your expert opinion, is that good police work? Okay, and then there's the psychologist, behavioral sciences, and investigation expert. The defense may also call a clinical psychologist with 25 years experience as a special agent with the Air Force Office of Special Investigations who holds the position of acting director, AFOSI, Behavioral Science Directorate. She will testify about Spencer's military training as it relates to his actions in this case. She will also testify regarding investigative techniques and interviewing, including explaining inadequacies of the interviews with Spencer and others after Fossler's death. She may also testify on how trauma impacts memory in addition to the effects of non-offending parents' psychological and physical health upon learning that their child has been SA'd. Her testimony is relevant to the charged offense and Spencer's justification defense. It is particularly relevant to whether the state can prove that Spencer acted knowingly and with extreme indifference to the value of human life, and to an assessment of the amount and type of force Spencer used. Given the state's comments in prior pleadings concerning Spencer's choice to pursue Fossler, to fire 16 times, to strike Fossler, and to take the law into his own hands, Spencer's knowledge of the situation combined with his military training and his actions consistent therewith are highly relevant to his mental state. Each of these experts is qualified, and each offers testimony that is relevant, helpful to the jury, and admissible under the Arkansas rules of evidence. The state has provided no authority or legal argument supporting exclusion of any expert for holding a pretrial hearing on this issue, or for holding a pretrial hearing on this issue. The state's request for exclusion should therefore be denied. All right. So that's deals with that. All right. Let's see. All right. So this was a quickie. It's just a renewed motion for discovery. Defendant filed a motion for discovery in this case on January 2nd of 2025, and they filed an amended motion for discovery in a brief and support in November of 2025. The defense is aware that the state compelled at least one, if not more, witnesses to attend interviews in connection with this case. The defense has not received any of those. Yeah, I think we saw all this. So they're saying there's more. There's more and we want it. There's more, we have a right to it. Okay. All right. Okay, and this is the response to the state's motion in limine to exclude evidence. seems like it's dealing with. Okay, so yeah, I think we just read the brief to this. So this is, again, trying to exclude the defense experts. They turned over the CVs. This is a substantial part of the anticipated testimony. The experts will be in consideration of in response to, yep, all properly qualified. Yeah, so that was what we just read that. I read the brief before I read the motion. All right, and this is the last thing that Tracy sent me, and this was filed today. Okay, so this is the state's motion to extend the deadline for trial motions and the briefs in response. So state of Arkansas, by and through, on November 24th and 25th, the defense filed additional motions regarding voir dire, the exclusion of cell phone tower data, alleged spoliation and destruction of evidence by Lonoke County Sheriff's Office, withdrawn its notice that Spencer acted in self-defense, and has withdrawn its motion to exclude irrelevant evidence of drug paraphernalia rather than agree with the state that it is irrelevant. In addition, on November 25th, the defense provided notice of another expert it has retained for potential testimony. Currently, the court has set December 3rd, 2025 as the cutoff date for all responses, and the time has passed for additional state motions. The state needs additional time to file motions to recently provided discovery and responses to the defense's motion based upon the substantial number of new and altered positions by the defense. The state would request an additional 10 days in which to research and draft said motions and responses. Okay. So we'll see if the judge grants that. All right. So there we go. Wow. That was a shit ton of filings. I think it was 30 plus. All right, let me go through the supers. So, look, at the end of the day, there's going to be hearings. I want to make it down. I want to do everything in my power to make it down for these motions in limine. I want to try to figure out when those are happening and if they're happening before I either take the flight or the drive down there. But I want to be there for the argument so I can report back to you. I need boots on the ground. I need to be there. I need to see it. All right, let's go through. Let's see what's what. All right, Maggie Cat, I think I gave you a family hug, but family hug, giving you another one. Thank you for becoming a member. Bailey B, member for 2 months. Happy Thanksgiving to my second family. We love you back, Bailey B. We're so glad you're fam these days. You came in and you've stuck with us, and we love that so much. Afton coming through with 5 DD podcast memberships. Thank you so much for your always giving. We appreciate you more than you'll ever know. Venus Blue Crash Baddie, link sent to family. Love you all. Happy Turkey Day. Back to you. We love you. Thank you. Bailey B comes in hot, making a donation for the Spencer family as well. Thanks for all you do. For all you both do. Thank you. And please, you guys, remember I brought it up in the beginning of the live, and I'm going to bring it up again. We've been dropping the link for the GoFundMe for Aaron's defense fees. They're substantial. They're trying to convict him of murder. He needs help. They need help financially. So anything you could do will be helpful. It's for certain. Thank you so much, Bailey. Meg is autistic. You need to talk to Bob Ruff about cell site stuff. Yeah, I have. I've talked to Bob about it. I know he got deep on Adnan with that shit. That's for sure. Thank you, Meg. Appreciate that. Petite Betty. Wow. Beautiful. I'm just arriving. Better late than never. I love you all. Happy Thanksgiving. Thank you so much, Petite Betty. How incredibly generous. Thank you. A million times over. Here for humanity. How's everyone doing tonight on this lovely Thanksgiving Eve? Thanks so much to Bob and Allie, Defense Diaries podcast, family hugs, sending warm, healing hugs, and love all around. What a wonderful, wonderful message. Thank you so much, here. We love you. Gobble, gobble. Happy Thanksgiving to you and your family as well. Thank you. Ladybug Lisa. His daughter may have asked him not to call police at first learning. I know because I was such a child. You are 100% correct on all of this. Thank you. Thank you. Yeah, I mean, nobody's changing my mind on this shit. Like, it's just like and the more I learn, the more pissed I get. Like nothing that I read tonight helped me not be more pissed. It made me more upset. Like the whole dash cam thing is unthinkable to me. It's just so fucking shady. But thank you so much, Ladybug. Appreciate it. Joey the Owl. Family hug. Remember, welcome to the fam, Joey. Happy to have you here. Foster was on bail, got SA against Spencer's 14-year-old daughter. With a no contact order, Foster violated his bail by being in his truck with her. No question. No question about it. Absolutely. 100%. And thank you for that. And then remember, for 3 months, JPJH, why was the dash cam sent to the AG's office? That's shit they're going to have to answer at a hearing. They're going to have to answer for their ridiculousness. I also got a few Venmos here. Venmos are our favorite. We love them because YouTube doesn't take a cut. Hannah sent us $10. Happy Thanksgiving to the Mata family. Thank you so much, Hannah. Susanna sent $100. Thanks for joining Runkle's extra live stream. Of course. Love Runkle. I'll always have Runkle's back when he's raising money for good causes. That's for sure. Will you be covering Antonio Brown's attempted murder bench trial? Hell yeah. When's that going down? Definitely. Presuming that they're going to be streaming it. It's in Florida, right? They're definitely going to be streaming it. 100%. Thank you so much for that incredible generosity, Susanna. That's amazing. Kristen sent $5 via Venmo. Happy Thanksgiving, Bob and Allie. Thank you, Kristen. Happy Thanksgiving to you and your family as well. And then Tracy told me to check PayPal. Let me see what's up here. Got a little activity. KPT. She said, I love what you're doing with your channel and I've learned so much. Well, thank you. Thank you so much. Thank you both for all that you do. Well, thank you so much, KPT, for that 15 glorious dollars. We really appreciate that so much. More than you'll ever know. More than you'll ever know. I'll tell you, I'm going to put on a super grift when I'm heading down to Arkansas. You guys are going to have to help me defray costs to report. Costs money, fly down there, hotels, all that shit. But I got to do it. And I'll be hoping you guys are going to help support that. So, all right, you guys are amazing. Thank you for hanging for 3.5 hours. There was a lot to go through. My hope is that you're equally infuriated after hearing some of these motions that were filed with some of the shenanigans that are going on with Lonoke County and the cops down there, man. It's just, it's an infuriating case in so many different ways. But hopefully you'll be on board. Make sure that you're liking, sharing, subscribing. It's like, I say it all the time, like Karen Reed's civil thing. I'm sorry. It just pales in comparison to the importance of this. There's probably people listening to somebody read through something dealing with Karen's civil case, which is fine. But this guy's life is on the line. Like, where are the people? Weigh things in terms of importance, what matters. Karen had her life on the line. She went to her criminal trial. She was found not guilty. That's over. Aaron Spencer is sitting with his life in the balance, trying to celebrate Thanksgiving with the only thing that he could probably think about is he's got this trial looming. The whole family's devastated. It's insane. So, spread the word. Let's get behind Aaron. Let's get behind the Spencer family. And, so if you're replay crew, please leave just any kind of comment helps, even if it's just replay, just to get it out there. I mean, I had a guy who I think's going to win the Emmy on our show yesterday. I would go so far as to call him a pretty famous actor. And we had like 500 people in here live. It's like I don't get what kind of content do we need to put on to be able to chip away at Karen Reed shit for a minute. I mean, the Karen Reed shit will be there. You can go watch that after the fact. Come over here live when I have a guy like Michael Chernus on the show. Seriously. I mean, it's crazy to me. Like, I don't know. I think our content's pretty damn good. So I don't know. I see things out there and I'm just left scratching my head sometimes. But enough whining from me. All right, y'all. We love you so much, mods. I hope all of you have an amazing Thanksgiving with your families, your loved ones. If it's a Friendsgiving, whatever the case may be, I hope that you celebrate each other, that you're thankful for each other's love and friendship, because that's so important in our lives. And to you guys out there, obviously, I hope the same thing. I hope that you guys all have a wonderful, healthy holiday with your families, with your friends, loved ones, whoever it may be. And if you're alone out there, just know that we're thinking of you, that we are your family as well, that you're not really alone. Even if you're alone on a day, you're not alone in general. You know, it's an important thing. I once had a very, I think it's on the docket, our podcast docket, and I went through it. Oh, you know what? It's actually in the Christmas thing that I did where I read Mark Twain's letter to his daughter, where I talk about holidays can be tough for some people because they don't have people, you know, and it's a dark time for them. I just want you guys to know that we love you and that we care about you and that you do have people. Sadly, we can't be with you on the holiday, but just know in our hearts, we're with you. Okay. Just know that it's important. All right. All right, you guys. I adore all of you, because remember, at the end of the day, without y'all, I'm just an old man bitching about why there weren't more people in the Michael Chernus Live. Happy Thanksgiving, y'all. Love you.